11 matter of 18. Is it? What is the matter? FT? Okay, we'll have it tomorrow then. 18. Item number 11. On a request made on behalf of the petitioner. Matter is adjourned to be listed tomorrow. Item number 11, no? Item number 11. Tomorrow. Yes. 13 and 14, yes. What scheme? Madam, what is this? Item numbers?
13 and 14.
13 and 14.
Lordship, they may apply there and keep it pending. In case they say that this matter has to be withdrawn, then they can come and withdraw.
The learned counsel for the parties have informed that there is certain development which may assist in resolution of the matter, which may come to the aid of resolution of the matter. In view of such submission, matters are adjourned to be listed after 4 weeks.
Lordship, in the meanwhile, Lordship may even direct them to apply Lordship because there's no bar in it.
No, that,
No, that date is-
those are not before us. We cannot say. It's up to you. You take some step, then to consider.
Yes.
After.
May I
Why
tell
should
you?
apply?
Yes,
My lord, I am for item number 23, my.
2, 3, yes.
Yes, this matter may be adjourned for the day, my. The London leading council is not available.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week. Yes, item
Okay.
23.
May I please, your lordship? My lord, I have filed this, my lord, writ petition, my lord, challenging the impugn opinion, my lord. Your lordship may have it, my lord, any day in this week, my lord.
Not listing, motion matter.
Motion, my lord.
Whenever you say.
Yes.
My lord, same pair, your lordship, third list.
Like you mentioned, item number 25. Currently be
Review. Review against which order?
Because the order of.
But you had taken time on the last occasion also.
Well, it may be listed after 2 days. Some difficulty with not to pay.
Okay, Wednesday. Wednesday, okay. On a request made on behalf of the applicant, matter is adjourned to be listed on Wednesday next.
May I please, lordship? My lord, I beg to pray for listing for motion, my lord. Oblige.
Lordship, I think 16 Lordship, that is a matter. Next week, Lordship.
16. Okay. On behalf of the petitioner, on a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
May I please, Your Lordship? I beg to mention item number 20.
20.
20.
Yes,
On behalf of KM Hassan,
Yeah.
kindly adjourn the matter for the day only. ma'am.
same matter, 1 week. Huh?
Published.
Same. 1-5. Yes, engage counsel. Who's the engage counsel? G Bora. Okay, same order, huh? 1 week.
May I please, Your Lordship? My lord, I have prayer in item 33, my lord.
Hmm.
This matter may kindly be upgraded, my lord. This is a habeas corpus petition. The lady is behind the bar, my lord. She was arrested on 23rd of May, my lord. And this was
We
listed.
cannot assure. All matters are
After
important.
motion,
We
matter-
try to upgrade, do a habeas corpus, but we
Yes.
cannot assure. There are motion matters, admission of 2018.
My lord.
We'll try to do it. Let's see.
I'm praying, my lord, just after finishing the motion, if possible, my
No,
lord.
admissions of 2018 are pending.
My lord, I leave it to Your Lordship.
We'll try any case.
Yes, sir.
You can provide your friend, nobody go and Fence to come over, fence with the right. ইমান তো ঠান্ডা নাই। ঠান্ডা লেগেছে?
সাফ না ফাইলটা খুবই সাফ আর সব কম নয়।
Yes,
Lordships, earlier this was directed to take instance regarding status of the case, my lord. I bring that. Instruction or status report.
yes, what is your case?
My case is that lordship, the daughter of the petitioner lordship, who married with the lordship, respondent number lordship. Respondent number 7 lordship, respondent number 6 lordship, so the 6 lordship. And just after marriage lordship, the respondent number 6 lordship take her to one break in the where he is working lordship. And from their lordship, she is missing. So thereafter, I filed one FIR lordship before the Shinapur police station, which was also the disturbance. The respondent number 6 was arrested lordship. And their lordship, he asserted that he killed my daughter. But body was not able to recover by the investigation. So
What is your instruction?
Instruction, my lord, they are police already searching various places, my lord. They have informed various police station also. But till now, they have not received that ladies.
It is not found on the field.
No.
What is in this status report which you had given earlier?
Earlier also, my lord, they are searching, my lord, at that time, my lord, in that brick industry was flooded area. They could not search it. Now they are searching everywhere, my lord, but they are not found.
What is the statement of the respondent number 6?
Respondent number 6, my lord, he is already arrested, my lord.
No, what is his statement?
Statement.
The case is registered under what sections of law?
Under my lord,
141.
Situation 142, under section 61 to 142/103, 1 BNS.
5 and 6 have been struck off. The names?
Your lordship, I have made the first lordship,
Huh?
and that's the number 5 years. That's the number 5 years.
5 is whom?
Because lordship, my allegation is that.
No, who for 5 and 6 have both been struck
No,
off.
no, lordship, 6 is her husband, lordship.
This is husband.
Who is the accused lordship.
Then whose name has been struck off?
5 lordship, that's the number 5.
Which order?
6, 8, 20. Order is the 6, 8.
Respondent 5 and 6 are not found to be necessary parties. Both struck off. Why?
5 and
Why 6 struck off?
Well, the main allegation is, lordship, the main duty of the investigating agency is lordship, to recover the body or lordship alive. So because so far as the petitioner.
Whether it is arrested or not. You have got the case diary.
Case diary is not here, man.
The statement of respondent number 6, whoever he was,
Then
it's been recorded. What does he say?
the case diary is not here, my lord. I will produce, if necessary, I will produce next date, case diary.
No, if he is the prime accused and he's arrested,
He is arrested and after this, he is on bail, my lord. Already after 90 days, perhaps he is on bail. And
Before we know.
no, this respondent number 6 might have been granted bail, but
yes,
during his custodial detention and interrogation, what did he say? Did you invoke 27 of the Evidence Act?
No. First trial is going on, my lord, now, lower court.
No, with this way, neither here nor there.
If lordship,
After habeas corpus, you cannot just act like this.
next that I will produce,
Was the case diary seen by this court on earlier occasions?
no, no, my lord,
You get the case diary
no, lordships. Lordship,
with the updated status of the
Case-
investigation. Okay. Third, your Barbuya and his Barbuya learned counsel for the petitioner. Courts have also heard 3 P. Sharma, learned state counsel, who has placed before us a report, a communication dated 14/11/2025, issued by the concerned officer in charge. Issued by the concerned Sonapur Police Station. Full stop. He has also informed that the prime accused, who was initially arraigned as respondent number 6, was arrested and was subsequently granted bail. Full stop. We direct the learned state counsel to produce the case diary of the concerned so-and-so case. When? Friday, can you get it?
no,
Friday?
no, 1 week time, my lord. Next one.
Okay, on request, list on Tuesday next. The report, the communication dated 14/11/2025 is kept with the records.
May please, your lord.
Yes.
My lord, behind this case, my lord, the interim order and lodge will find at page 16. The record was all for, here the petitioners, they are all brother and sisters, they were declared foreigners by an ex parte order. My lord, I have 2 submission in this case. First case is that.
2013 order.
13 order, notice was never served.
No, when did you come to know about
My
this
lord,
order?
we came to know in the month of June 2025, when the police has searched them. And BDB secretary has informed them. My lord, I have stated at para 2. Before that, we don't know. And we kindly see the process server report at page 14 backside. Notice could not be served because they have served the house, could not be test out the house. And somewhere
Where do you get this process service report?
my lord, at page backside of page 14.
40,
Page of the record.
1440.
One
The record.
record, my lord.
Yes.
My lord. Page 14 is the notice, and in the backside of the notice, this note has been, process server report note has been given. সম্মানপূর্বক বিনীত নিবেদন এই যে মোতায়েন মতে যথাস্থানত গৈ জাননীত উল্লেখিত ব্যক্তিগণৰ সরজমিন তদন্ত কৰি ঘৰ বিচাৰি নাপায় জাননী 2 গৰাকীৰ সাক্ষী সহি লৈ লটকাই জাৰি কৰি মহোদয়ৰ জ্ঞাতাৰ্থে মই প্ৰতিবেদন লিখি পঠালো where has been the lotka jari has been done, where that has also not been mentioned. My lord. As per the provisions of law, it should be pasted on the back, on the outer door of the house. They have paid this space out there. My lord, this is my one point. Notice was not served on them. My lord, kindly have a look at page 2 of the report. page 2 of the record. Enquiry was directed to be conducted someone, but these petitioners, the case has been proceeded against them, without enquiry. my lord. I have also annexed in the petition about the order of the Superintendent Police Morigao. The enquiry was directed to be done against one Musammat Jaida Khatun, not against this petitioner. And Jaida Khatun, my lord, admittedly the mother of the present petitioners, and she has died in the meantime. I have also annexed the death certificate.
And the last line, and his family members,
My lord,
the report which you have,
my lord,
relied upon.
my lord. জাননী দুই গৰাকী সাক্ষী সহি লৈ তৎকাল জাৰি
No, 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 not that. You had referred to page 2 of the report.
Yes, my lord. Yes,
Page 2, you said it's the name of another person
yes, my lord.
whom you say is the mother of the petitioner.
Present petition.
And there is also a reference and the family members, not only her.
No, my lord.
There is,
When the enquiry is against Jaida Khatun, reference shall be against that person.
you see, we are aware of that. but still-
Mere make enquiry should be particularly against that person. My lord, we have also judgment in this case. My lord. In the Sudhir case,
That part is clear, but there was a enquiry done against all of you.
no, my lord. The order for enquiry was against Jaida Khatun. Merely some family members' details is mentioned in the enquiry report. That is not enough.
No, 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 it's not there in the inquiry, not on the reference is against all of you.
No, my lord.
Yes, have a look. We know the proposition of law that
My lord.
without there being a reference, you cannot, there
My
cannot be an
lord,
opinion.
the order of SP in Morigao
Yes,
is in my writ petition also I have annexed is
yes.
48. It is to the SI Dhoniram Kakoti of Jagirot PS. It has been learned that Sri Musammat Jaida Khatun, wife of Mafizuddin of village so-and-so, district so-and-so, Assam is suspect to be
And the
illegal
last line,
migrants.
last line. By hand, same authority has written by hand.
And his family members.
Yes. You cannot say there is no reference. It will be a different matter where reference is not at all there. The final question will be whether there can be, by one communication, there can be more than one reference.
My lord.
Because what is the purpose of having a reference before you declare somebody to be a foreigner? So that a preliminary inquiry is made, satisfaction arrived by the concerned authority, then matter is sent.
My lord.
So we cannot just straight away put that principle that without there being a reference, that is the proposition, we know about it.
Sir, kindly have a look at the enquiry report. When other family members are dragged in the proceeding, in the enquiry, then their statement should be recorded. Whether their statement has been recorded, only my lord, statement of Jaida has been recorded, not the other persons. So enquiry report, I perhaps, my lord, I have to see.
Now,
my
Mr.
lord,
Sikdar, the first point which you had urged is the ex parte point.
expert.
If you're successful in that point, then there is no question of putting forward any other arguments, because the matter has to be remanded, it has to be adjudicated on merits by the authority.
My lord, this point also may kindly be considered whether.
And if you are considering that point, we have to consider everything. We are not the primary authority. Primary authority is the tribunal. We are simply
But the
exercising.
settle law, law
We-
settle is that
This is
when-
either we are exercising certiorari jurisdiction, whether the opinion
My
is
lord-
bad or law in.
my lord,
in
there
law.
is settle law of this old court, my lord.
Yes.
Sudhir Roy case, my lord, reported as 2019-20361. I have.
So that is what we are trying to
My lord.
point it out, that there is a distinction. A person against whom there is no reference and he had proceeded, and by one communication there are reference to one person and his family members.
Other, yes, my
So
lord.
there-
And
there
it
is
should be
the-
made against other families.
So there are distinction. This point you can raise before the tribunal.
My lord, the law has been settled by this honorable court, my lord. If, my lord, enquiry has been in fact and conducted against these persons, then, my lord, I am not basing on that, my lord. Kindly have a look at, my lord, whether the statement of the other persons were taken or not.
So whether those were.
Simply inquiry, my lord, interrogation against one person. It
Mr.
does not
Sikdar,
amount that the inquiry has been
Sikdar,
conducted against those persons.
Sikdar, our limitation to go through the records is only on those materials which were considered by the tribunal. Do you get our point?
My lord.
Whether the opinion rendered is based on relevant materials, whether it is based on irrelevant materials. With the records we produce and inspect only for that purpose.
My lord,
If you make out a
far-
point, you can make out a point, but this will
my
be.
lord, so far my understanding, my lord, the whole proceeding is illegal, not for one grounds. There are several grounds. My lord, the tribunal is to look into what matters collected and laid down before the tribunal. And tribunal is to consider in the light of the full bench decision, whether the sufficient materials has been collected against this person or not.
Let us
That's
read
when
the,
also,
let us read the tribunal's opinion again.
my lord. At page 60.
Is anything mentioned regarding all these things? It is simply an
Nothing.
ex parte order.
Nothing has been mentioned, my lord.
So our examination would be on the basis of what the findings are based on. If you can make out a case that the Jari Karak's report on 14, backside of 14 is not in accordance with law, which probably you are trying to make out a point.
My lord.
It has to be a conspicuous place where he had last resided or known to have resided. Jari Karak has not said where he has pasted. That you may have a point. We'll inquire. We'll get their issues. Get their views. But without there being anything written in this opinion, how do you assail this
My
opinion?
lord,
On what grounds?
the record is available before.
We are not going to see the records. We are not the primary authority. We will not make that mistake.
Well-
We are exercising tertiary jurisdiction to be very, very particular.
Well,
Yes, madam.
Thank you, sir.
Who's appearing? Any question?
but record to size है ना?
What size notice?
है ना record है?
My
My lord, my lord,
Just a minute, 159.
Notice of videos. Notice of.
1 minute. 159, person. 59, 159.
One is out.
Order three, order three. Order three, huh? Order three. Order three, subsection 4. Subsection 5. 5 was what we. 5 was F before.
Last slide.
That part was not there. Regarding.
When you last said, very last slide.
Very rough, conspicuous of the house in which the procedure ordinarily resides or rough resided or reportedly resided. Inside. Yes. So it is, Jari Karak has not said, no fixed.
Might be incomplete.
Because this G is also ready. Verifying. Notice of event of the animal.
Lordship.
Yes.
And his family members.
And he to no, he's no to har.
His family members, his children, no?
He's no hoy.
His ঘর তো এনেকা চলি থাকে।
Also.
Notice was, Lordship, I have just gone through it. Lordship, notice and was given to the last resided address only because the address is same in the opinion also and in the inquiry also. Sorry, Lordship. Yes, exactly. That part is not clear, Lordship. That is the only thing which we are finding it here.
Yes.
Stated, yes. Very close. But it is this, yes. Yes,
Yeah.
Lordship.
5F.
5F, Lordship. If the proceeding has changed. Yes. Or reportedly. Enough. Yeah, Javika. Lordship, sometimes what happens, they know that there is a proceeding, they evade the notice also. Yes. Affects the notice, Lordship. Known place. Or if they have changed their residence, it is their duty to inform the police station also. Lordship, they know there is a reference because the mother passed away only in 24. All along she knew that there is a reference against her. This is from 2001, Lordship, when the first inquiry. Lordship, I'm making it because when the inquiry is done, they're much aware of it. Only after the inquiry is done, after a few years, the matters are sent to the tribunal, Lordship. Not completely. Yes. And Lordship yes, Lordship, and completely saying we are not aware of the proceeding is also wrong. Yes, I agree to that, Lordship. Reference. And his family members. Proceeding. Tribunal. Yes.
Law that if one person is declared foreigner, the other cannot be declared foreigner without the reference.
No.
We find that they're referencing.
Yes.
Now, whether they can declare foreigner or not, after it, that's different matter. We cannot tell it now. Or because they have to close.
It was judgment to
That is
the
only put it right.
everything we might request the family members.
That is fine.
My lord. That is then, my lord, I have, my lord, due records the opinion of this rule court, but I am to say, my lord, the order or order for inquiry of other family members was not complied in this case. Only inquiry in fact against one person.
No.
Record. Only against one person. The other person ought to have been interrogated, that was not done. They are to be interrogated as per the technical law. Yes, the lordship view is my.
Anything else?
No, Lordship. Requirement of private movement upon positional was not increased in accordance with law. Here, in regard to record to the foreigners, related title order 1964. More particular support, order 3 to be ratified on the as. Here, we report that purpose. Is there in the original record. There also improved that. No.
Report we have improved.
We have not enclosed in the petition, but it is in the record, my lord. No, processor report I have not, my lord, we have, my lord, we have got a certified copy. Well, then.
Has not been report dated 16/8/2020.
Item 2 file as sir.
I think 3.
There are no was as these found as the petition There is no way that you wear but this yes, particularly. That is required is in motivation, in can only only outer loop of the or any other was the heart of the house. In which the position and not that is. These are to the forum of the patient. Border was not eating with location, but there it is further mother who is inside has not. Here also. In house here, I think, and that reference.
No, 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 madam, immediately. No, madam.
In this case, James Sulaiman will appear. I have called him. James Sulaiman will appear in this case. Related to the called him. No, I have not appeared.
27/8/25 opinion.
Yes. Sorry, Lordship. A contested case, Lordship. The impeach order in page 61. Date, Lordship, 27/8/2025. Lordship. 27/8, Lordship, 84 days, 82 days, Lordship. Not Lordship, outside. Sure, sir.
The Sharma has got the information that you are arrested this morning. Yes. As we get them to the yes. Lordship. Yes, sir. And these are not
2, 5,
2, 5, 6.
6. 2, 5 and 6.
Negligent practice, Lordship.
Except for your complaint in the bottom of the year, you got that?
No.
You have not done that, so this will not be. What the action will be taken, inshallah? Again, this is the sort of thing, are we confident?
Petitioners complain that his negligent practice was
Why
negligent.
is complaint against
It's
the,
not correct.
it's no action taken, they should not report, there is no different matter. There's a difference, for the territory. Yes, sir, yes. Yes. I will find. Fine. Please enter. On the next day, 31, 7, there was no representation on the petition. And on 29, there was again, government was also. By petition. But you have something. There were quarters, no representation. On the 22 page, and on the last page, 31 page, right. This court, after measuring matter on the fair of the public was there, and also remarked that it is more valid matter, right? Either be there and another chance to use the petition, and then have to give it for consideration. In this case, that is the further on with the I can say
The petitioner was declared to be a foreigner.
yes,
Post 71 stream area. Admittedly, the documents that were exhibited does not help her much to establish the linkage. The only thing is that there were two DWs, elder brother and younger brother of the proceed. Their evidences were discarded by the learned tribunal, stating that since their name were not mentioned in the written statement, that could not be believed. I came across a judgment of this honorable court reported in 2021 5 GLR 409. I'll seek some time to go through this one because it speaks that WS in a
is I don't expect Christian version.
in that event, I'll try to convince the lordship. The impugned order starts from page 28, your lordship. And as admittedly, the documents does not help me much. I'd like to take your lordship to page 34.
Whatever the law.
Yeah.
That there can be defense witness apart from the proceeding.
Yes.
And for the burden upon you. But case the defense witness is not an official witness, but it can be or a cousin. Without there being a difference of your first sibling or a cousin, either or in the evidence of the this there entering to the role as a witness is itself a matter which would be good to the sample.
Yes.
We can work on this. And for sure will not make it really in a. Okay. After that, we also could access this. Why is it not very involved? Currently,
Lordship,
you can show it on the voter list here, somehow the network. The voter list is my father, my brother, and I.
here in this case, the lordship, as the petitioner.
To work on this,
Lordship, as the petitioner got married at a very tender age, she could not produce any voters list showing her name at a tender age. Lordship, I would like to take your lordship to page 34, para 20 of the judgment.
What measure is? What was the
Lordship, I have to go, exact date is not given.
age, ground?
Exact age is not given, around 16.
Actually, some say 10, if you know not then 30.
Judgment, without going through the entire judgment, your lordship is 91. Opinion starts at 28. I would like to take your lordship to page 34 at para 20. Para 20. I am just trying to make out a case out of this paragraph, your lordship. Otherwise, the link is not well established by my document. Para 20, if I may read. 20, at page 34. One Umesh Sarkar, who stated OP as his younger sister, examined himself as DW2, and one Sujal Sarkar, who stated OP as his elder sister, examined himself as DW3. However, the OP DW1 in his written statement and evidence in chief nowhere stated that DW2 and DW3 are her brothers. On this ground alone, the statements of DW2 and DW3 are not trustworthy.
Mr. Sharma, we had one case where you had said that it was adjourned
Yeah.
for some development
Lordship.
after the CAA.
Yes, Lordship.
What about this case?
Lordship, I think, Lordship, he will know.
Because he's not saying anything.
He will be benefited or
But
not,
we cannot, from our own, but interest of justice
Yes,
would
Lordship.
require.
I may apply for that.
But that is not coming from you.
The case is pending, your lordship, and I did not take it.
No.
That cannot
Even in a pending case.
I can apply for that.
Now, we do not know whether you apply or do not apply. First, whether it will be applicable to you, that is also one question. We do
Yes.
not know.
Lordship.
Because surname will not determine anything.
Mm.
Who are you? We do not know.
Otherwise, the documents other than the linkage, which show my long residence in India from the date of my marriage, at least 89, is well within the records, your lordship. In that view of the matter, I may be allowed to apply under CA, your lordship.
That we cannot say anything.
Yeah.
It has to come from you and we can give you some time to,
For application.
not for whether your application will lie or not, that also we cannot say.
Yes,
The state
yes,
will
Lord.
determine.
Because we are very clear, only because you write some sarkar that you will be out of this proceedings, not like that.
That will be examined by the state level.
We are on the aspect of nationality. We are not on the aspect of religion. Whether you get the benefit of some CA or some, that's it.
That depends on the state.
Depends
In
on
the
the-
view of the matter, I pray for some time so that I can apply for that, your lordship.
Yes, what you say,
Yes.
but 18 matter, we cannot grant you
Yes.
too much time.
Mm.
Are you in touch with your clients?
Yes, ma'am.
Okay. The learned counsel for the parties have submitted that there is some development after enactment of the CAA. CAA,
Yes, Lordship.
booked up according to some time is sought for to obtain the latest instructions. Booked up para. The case is pending since the year 2018, full stop. Para. Balancing the equities. We are of the opinion that an opportunity may be given to the petitioner to explore the options available. Para. List after 4 weeks. But after 4 days, you are going to adjourn.
Yes.
Adjudicate on merits. Next.
Item 7.
সেখানে গিয়েছিল
Records are there. We'll go for a final disposal.
I may allow to see the LCR lordship.
Yes, yes, please. Record. Which page, Mr. Chaudhary?
Opinion, space 65.
65. Just a minute.
Yeah. Mm.
65. We'll hurriedly go through the opinion, then we'll come to your arguments. Okay. Mr. Sharma, have your seat.
Look. Originally, the order of reference was made by ASP Kamrup as Amanda under the FP police case number 105 2016, expressing doubt about the nationality of proceeding opposite party after Chelsea OP, namely Malika Madam, resident of above referred address to ascertain and accordingly give opinion as to whether the OP is or not a illegal migrant. In as much as he is suspected to be a foreign national and has entered into India as illegal migrant from the after 5 March 1971. Subsequently, this case was registered as per Foreigner Act 1946 as RFP case number. And so, before the foreigners tribunal Kamrup are 5 fifths. On receipt of notice, the OP above named appeared before the tribunal and filed against government. The OP claimed herself to be Indian citizen. Thereafter, the OP also deposed her own evidence before the tribunal as DW1, asserting the plea stated in the case in as much as the burden of proof one's nationality lies upon the person against whom the case is filed in view of Section 9 of the Foreigners Act 1946. In her deposition, the OP stated on oath that her actual and correct name is Mallika Khatun, but in the present year, her surname was wrongly written as Begum instead of Khatun. However, other particulars in respect of herself are found to be true, and therefore she appeared for the trial. As stated, she was originally a resident of village Narayangaon under Paschim Banga PS Bhagrapur, earlier Nalbari, the district of Nalbari, earlier Kamrup. She was also born at village Narayangaon in 1979. Exhibit 1 is her PAN card, to that effect issued by the Income Tax Department, Government of India. The OP father stated that his father's name was late Moharuddin, son of Zaharuddin, and mother's name was Moina Nessa. She did not go to school and later on got married to Nazimuddin Ahmed, alias Ali, son of late Bilal Hussain, a resident of village Ishapur under Romia police station in the district of Kamrup. Exhibit 2 is the voter ID card pertaining to the aforesaid village Ishapur under 57 Romia LSC issued by the Election Commission of India, proved in original. Exhibit 3 is the certified copy of NRC 51 issued by OC Guwahati, Guwahati Jamia Ulema Hind, dated 5/6/79, in respect of her paternal family pertaining to the aforementioned village Narayangaon. wherein her father's and mother's names were appeared at serial number 3 and 4 respectively by objection. As it was an attested copy attested by school headmaster, dated 010615, with 4 and exhibit 5 are two certified copies of draft data for the year 1957 to 64 in respect of her father Moharuddin along with her uncle Tabaruddin, Samsuddin, Muslimuddin, and Hasmat Ali. All are sons of Zaharuddin pertaining to that number 804 of 94 and 804/94, 508, 518/116, respectively for the ancestral Keras Exona land at Iles Narangam and Kosim Banbhag Moja. Exhibit 6 is the certified copy of voter list of 1971 in respect of her uncles Haji Tabaluddin, Samsuddin, Muslimuddin. All are sons of Zohar pertaining to 64 Bolbhag LAC at aforesaid village Narangam. Exhibit 7, Exhibit 8, and Exhibit 9 are the certified copies of voter list of 1985, 87, and 2014 respectively in respect of her uncle Muslim Ali and Muslimuddin, son of Zohar, pertaining to 59 Nalbari LAC at village Narangam. Exhibit 10 is the certified copy of her marriage. Registration deed dated 22/5/95 before the sub-register Romia. As stated, her husband's actual and correct name is Nizamuddin Ahmed, son of late Bilal Hussain. However, on some occasion and in the voter ID card of OP, his name was written as Nazimuddin Ali. Exhibit 11, Exhibit 12, and Exhibit 13 are the certified copy of voter list of 2011, 2013, and 2018 respectively in respect of OP. Pertaining to 57 Rumia LAC at village Isapur. Exhibit 14 and Exhibit 15 are two residency term linkage certificates in favor of OP issued by government Lat Gamuda of our original village Narangam. Exhibit 16 and Exhibit 17 are two affidavits shown by the OP before Notary Romia Assam in 2017 and 18 with regard to some variations in the name of herself and her parental family members. AGP was absent, therefore cross-examination was deemed to be declined. The court asked questions to OP under Section 165 of Evidence Act 1872 to examine the veracity of his deposition. In reply to court query, the OP could not say as to why her father's name was not enlisted in voter list of 1965 or and onwards. She lost her father at her very childhood and heard from family members that he died after prolonged illness. She also would not say her exact date of birth, but it was around 1979 as heard from family members, and it might be a cause for in her different documents her age had legal variations. The OP further stated that the name of her mother-in-law was late Hazra Banu. At the time of her marriage, her father-in-law was deceased. However, mother-in-law expired after her marriage. The OP further stated to court that in their registered marriage, the Exhibit 10, 1 is the relevant entry for corresponding for the occasion when it was originally executed. Similarly, Exhibit 10(2) is the relevant entry for and then 14/7/2015 corresponding for the occasion when the certified copy of the original was prepared in 2015. OP revealed that she could not say the exact date of birth, but the year of birth was 1963. The father stated that her husband is still alive. So far her knowledge is concerned, the name of her husband is Nazimuddin. However, could not say whether the surname is Ali or Hussain. She submitted that in their registered marriage deed, Exhibit 10.
Not submitted, admitted.
She admitted that in their registered marriage deed, Exhibit 10, her husband's name was written as Mohammad Nazimuddin Ahmed of village Borazal and Gograpar. Yes, in the district of Nalbari, exhibit 10(3) is the relevant entry of signature with seal of G. Sharma, cab register Romania, dated 22/5/95. On the day of original execution of said marriage, the OP denied the suggestion, saying, as it was not a fact, that exhibit 10 was not the registered marriage deed in respect of herself and her husband. As such, the position of OP was very shaky as well as inconsistent. Mohammed Abdul Motin, an agent resident of village Gagari, Narayangaon, adduced evidence as DW2. He stated on oath that present OP Mallika Khatun, daughter of late Maharuddin, was known to him, inasmuch as before her marriage, they were the co-resident of village Narayangaon. She was also born at village born at this village. Exhibit 18 is the voter I card of DW2 pertaining to 59 Nalbari LSC at village Gargari, issued by the Election Commission of India, proved in original. The present OP Mallika got married to one Nazimuddin of village Ichapur. DW2 further stated that the name of uncle of OP Mallika are Sabladdin, Samsuddin, Muslimuddin, and Hasmat. However, all are deceased presently. Muslimuddin expired about 3 years ago, and all were ordinarily resident of village Narayangaon till date. Of course, other family members, Moruddin, are still residing at the Narayangaon, and they have also landed property in village inherited from ancestors since long ago. The court DW2 stated, DW stated that presently he is about 71 years. And Moharuddin, the father of OP, was elder than him about 15 to 20 years. He expired many years back after prolonged illness. However, DW2 could not recollect exactly in which year he died. The mother's name of OP as Moinanisa, since deceased. The village Gargari and Narayangaon are two adjacent locations. Earlier, DW2 resided at Narayangaon, and since last 15 years, he is residing at Gargari. DW2 added. The evidence of DW2 was not so sound to support OP. DW3 as Sri Arvind Das, government Gaambura village Jali Jaljoli, Koponni Kusi, and Ishapur. Exhibit 19 is his identity card issued by Circle Officer Romania, dated 5/10/2012, proved in original. He knew the present OP Mallika Khatun, wife of Nazimuddin Ali, as she is the ordinary resident of his jurisdictional village, Itapur, after her marriage. Exhibit 20 is her residency certificate issued by DW3. He further stated that the present OP was originally a resident of village Narayangaon under Gograpar PS in the district of Nalbari, Assam, and her father's name was Late Maharuddin. To court, DW3 stated that the name of father-in-law of Mallika Khatun was late Bilal Hussain. However,
Bilat.
Bilal
Not Bilal, Bilat Hussain.
Bilal Hussain. However, he could not recollect the name of mother-in-law of OP. DW3 divulged that he never met father of OP, but could know about their family at Narayangaon from the Gaambura of village Narayangaon, namely Babaram Boro. DW3 further states that he doesn't maintain any register with regards to birth and death of people residing under his jurisdictional village, and issued Exhibit 20 from the personal knowledge. In view of the above, this evidence cannot be acted upon for linkage by virtue of Section 35 of the Evidence Act and with the ratio of case Rajendra Kumar versus Chandra Narayan Singh reported in 1970 277. No evidence was reduced from state prosecution side. Now, the point of determination is whether the present OP is an illegal migrant entered into India illegally from specified territory after 25th March 1971. To decide this issue, endeavor be made to appreciate the evidence on record. I also perused the CS, WS and heard the learned council of opposite party. Be that as it may, Exhibit 3 NRC 1951 is under objection as it was certified by an officer in charge of Guwahati Jamiat Ulema Hind and was an attested copy attested by a school headmaster, which is not reliable piece of evidence. However, Exhibit 4 and Exhibit 5 draft data for the year 1957 to 64 of village Narangaon in respect of Moharuddin, taken to be the father of OP, along with her uncle, give rise to a presumption that they may be deemed to be Indian citizen under Section 6A of the Indian Citizenship Act 1955. Other voter lists submitted herein in respect of Haji Savaluddin, Shamsuddin, and Muslimuddin, stated to be the uncles of OP, corroborate the same. On the other hand, Exhibit 11, Exhibit 12, and Exhibit 13 voter list 2011-13 and 2018 together with Exhibit 2 voter I-cards in respect of OP pertaining to village Isapur speak that she is the wife of Nazimuddin Ali of village Isapur after marriage, but OP failed to prove cogently that she is the daughter of aforementioned Moharuddin of village Narangaon, who may be deemed as Indian citizen as discussed in Para 9, Exhibit 1 PAN card of OP speaks only that she is the daughter of one Moharuddin, but in PAN card we do not have any address, and as such, the same does not suggest that said Moharuddin was the resident of village Narangaon, who may be deemed to be an Indian citizen. The OP further submitted Exhibit 10 registered marriage deed to establish her linkage with father and husband both, wherein said both parties' names were mentioned as the OP claimed. However, after meticulous scrutiny, it is observed that in this regard, marriage deed Exhibit 10, her husband's name was written as Muhammad Nazimuddin Ahmed of village Borazal under Ghagrabar police station in the district of Nalbari, but as per her voter list as well as voter card, she is the wife of Nazimuddin Ali of village Isapur and under Rungya police station in the district of Kamrup. On the other hand, OP stated in her evidence to court that so far her knowledge is concerned, the name of her husband is Nazimuddin. However, could not say whether his name is Ali or
Surname is. Whether his surname is Ali or Hussein,
Yes.
not name, surname.
in this
Whether his surname is Ali or Hussein.
surname is Ali or Further, as the OP herself admitted, Exhibit 10-2 is the relevant entry for corresponding for the occasion when the certified copy of the original original registered marriage deed was prepared in 2015. And Exhibit 10-1 is the relevant entry. The date 25/5/1998 corresponding for the occasion when the deed was originally executed. But Exhibit 10-3 is the relevant entry signature of the seal Sharma, Sub-Register Romania, dated 22/5/1995, that is the day of original execution of state marriage deed, such which transfer a cleansing inconsistency. In fact, it is date of issue of certified copy at the register. There is no inconsistency. Exhibit 10 is a cloudy one, and such is not a reliable piece of evidence and therefore discarded. Furthermore, the OP did not furnish the said original deed, although the same was of 1995 for the reason best known to her. Moreover, OP divulged that she could not say her exact date of birth, but the year of birth was 1963. But in her evidence, in chief, OP stated that she was born at village Narayanpur in 1979, and her PAN card, voter card suggested the same, which shows also a major contradiction. As such, no credible proof was there as to when or where OP was born born to attract Section 3(1) of Citizenship Act 1955 for the proof of citizenship of India by birth. The OP further stated that her husband is still alive. However, he did not turn up to adduce evidence for OP, that is, for his wife already. It is discussed in paragraph 6, 5 and 6 that evidence of DW2 and DW3 also cannot presently attach upon for linkage of OP. It is pertinent to observe here that two residency and linkage certificates stated to be issued by one Bhabaram Boro, the late Gaumbuda of
Not late, Lord Gaunbura.
Sorry, the Lord Gaumbuda of village Narayangaon were submitted by OP Exhibit 14 and 15.
Gaunbura did not turn up.
However, the Gaumbuda did not turn up before this FT for his evidence and thereby to prove the certificates. As such, the same are discarded. Furthermore, the OP submitted her PAN card, but she neither submitted the income tax return nor described by any reason for which she procured the PAN card. Moreover, not a single voter list in respect of her father was submitted, although submitted the same of her uncles, and claimed that her father was ordinarily a resident of Assam since 1951. After all, everywhere some lacunas and insufficiency of documents were there, but the OP could not fill up the holes. In the light of the above, it is observed that the proceeding has miserably failed to prove her case, inasmuch as she could not cogently establish her linkage with one Moharuddin as her father, although said Moharuddin may be deemed to be Indian citizen, and therefore my opinion is that OP in the present case, namely Mallika Begum Khatun, is a foreigner of post 1971 state. Hence, issue of the reference is decided upon for this. DW2 and 3, he has linked her that her father was Moharuddin, and Moharuddin, by document also Moharuddin was a citizen of India, and it is admitted in the admitted position in the judgment itself. Moharuddin has got the Sikha record in 1957 and 64. I am showing the documents. Plus 6,
Page?
Page 30. The original in vernacular, that is in page 31. It is the copy of 1957-64, son of Paschim Banbhag Mojar, Narayangaon. Tag number आपको sorry. Here the name of father is written. Kawaluddin, Moharuddin, Samsuddin, Muslimuddin, Hashmat Ali, Pita Zoharuddin.
This is what is this document? Jamabandi?
Yes, sir.
Jamabandi?
It is Sikha record.
Draft Chita. What is the description of the land? Dag number 804.
80. Plus 94, 419. Land quantity 3 bigger to 2%. Moharuddin's brother's name are here, along with Moharuddin. Moharuddin is her father. Samsuddin, Muslimuddin, Asmat Ali, all are sons of Zohruddin. Next, my lord, Annexus 7. This is also copy of draft Sita of
These persons are, what is the name of the father? Pita? Baharuddin?
Zohruddin.
No, not her father, her grandfather. These
Grandfather.
4 persons are the sons of who? Baharuddin,
No, Zohruddin. It is
Joharuddin.
Yes.
Oh.
It is not Zohruddin.
Acha, acha. Joharuddin. What about the voters list of your father? Not there.
No, not there. Only my uncle's photo list is there. That is of 1971. The annexes,
So what is your explanation? Father's voter list is not there. Why?
he died long back. It is the explanation that
When did he die?
age is also not in the evidence.
What date of death? Year of death?
15 to 20 years as said by the AW2.
DW2 is a brother of the deceased father,
No, no.
uncle.
No,
Who is DW2?
Eleazar, none of the brothers alive, were alive at the time. While the
The petitioner is the DW1.
yes,
Then DW2, co-villager, villager.
villager of Narayangaon. There is another land record.
He is a villager of Naranga, DW2.
DW.
And who else? Who is 3?
He is Kambuda.
Of which village?
He is not Narayangaon. He is not from Narayangaon.
And which village?
His village is present Zoljoli. I decided at present in Zoljoli. His evidence is there. Earlier he was from Narayangaon. That you will also find in page 69, page 64. DW3.
So this land document is of the year 1957.
There are another land document also. That is.
And what is your connection with this land document?
Because Moharuddin, whose name is recorded in the land record,
Correct.
and he was my father.
Now, how have you established the link of you and Moharuddin?
DW2 says that I am the daughter of Maharuddin.
No. Documented evidence.
Documented, there is no documented.
Then without documented evidence, oral evidence, will it be enough?
There is no documented evidence.
In a matter of foreigners,
But
tribunal will,
what is there in the record I have said?
no, that is it. But the established principle of law which has been laid down.
Well, the documentary evidence regarding her connection with Maharuddin, that is not there.
Then how do you?
Only just.
What is your age? What is your age presently, Mr. Chaudhary?
According to her, she got birth in 1979.
The date of year of birth 1979.
Yes. But the date could not be furnished.
It doesn't matter. 1979. So you'd be around 45 years, 44, 45 years of age now.
And according to the statement of the.
When did you first vote? Have you enclosed any of your voters list?
1985. Next. Page 50.
50.
50.
Yes.
Mallika Khatun, wife of Nazimuddin.
Your age, this is of 2011. You're already 31 years.
Yes.
So you have been voting at least from 21, if not 18. When did you get married? Date of marriage, year of marriage?
95.
Year of marriage 95.
22, 5.
You got married at around 17 years of age. So that is your explanation. You don't have a voters list along with your father.
Yes.
But there has to be something else. Did you go to school? Are you literate? Did you go to school?
Pardon?
Did you go to school?
No. See, according to her statement, I did not go to school and later on I got married. She did not go.
But without any document, how do you establish a link?
Only link, here in this case, I have found that the statement on evidence of DW2 and DW3.
That is not documentary evidence. We are on the
No
requirement of law.
There is no documentary evidence. They are connecting her next with father.
But you know the principles of law. Mr. Sharma, please give your senior colleague the principles.
Okay.
Yesterday also, Friday also you had given to my
Yes, sir.
placed two judge, relied upon two judgments.
Yes.
Even father's evidence is not enough.
Yes, Lord.
Mother's evidence is not enough without a document.
Yes.
And here one is a villager, one is a
Gabra. Of different villages.
Not different village, of the same village.
No, but even the father's evidence that he is my daughter or he is my son, that has been held to be not enough, and that is the law. No, even if it's the court,
I've gone through it, but her statement is she was illiterate totally. And regarding document to show her name was disconnected with his father. The respect to the illiterate family, it may not be possible. I cannot defy this finding of the court.
Yeah, that is what is also confronting us. This is a coordinate bench which confronts us, even mothers, oral evidence, fathers, oral evidence.
Our reality of this society is that.
But we have also seen the logic. The issue which we are dealing is a very serious issue for the state, for you, the individual, and for the state, a major issue.
Yes.
So a balance has been struck in both the matters. Anything else, Mr. Chaudhary?
Nothing to similar on record. These are the materials in favor of her. DW2 and DW3.
DW1 is the Proshidi, correct?
DW2 and DW3 are the co-villagers.
DW2 co-villager.
Co-villagers earlier, and one is Gambura at present.
DW3 is the Gambura.
Gambura at present.
Of which village?
Joljoli.
No, but she was born where? Narayanpur.
But his statement is that he was earlier at Naranggaon.
Has he stated what is the distance between Naranggaon and Joljoli?
This is not. This is not. Yeah.
How can he conveniently say that earlier he was in Naranggaon?
He was.
If he says it may be a fact, he has to say that this is the distance, for this reason I have shifted. And that too, he is a Gambura. Gambura has to be from the same village.
The present OPU was originally a resident of village Naranggaon under Ograpar PS in this district of Nalbari. Her father's name was Late Mohoro.
And where is Joljoli?
Joljoli is in Kamrup district.
Not in Nalbari district.
I am the government Gambura of village Joljoli. Poponi Kusi and Ishapur.
Naranggaon is in Nalbari.
Yes, Nalbari.
And this Gambura, he goes from Kamrup district.
Gambura is from the village where her husband resides. Husband.
So how does he know?
He
can certify only the marriage. Yes.
He was originally a resident of village Narayan. This is
No, Mr. Chaudhary, just to examine that statement, if the Gambura is from the village where she is presently residing with her husband, he can certify only of her status as a resident of the present village.
But
He cannot go back to the village. If he goes back, there has to be some record.
because that petitioner got married to a person of the Ishapur village, Nazimuddin. Her husband is Nazimuddin.
No, that is what we are saying.
So,
From the date of the marriage, from the date,
of marriage,
he will know, there is no doubt.
Yes.
We are not on the date of the marriage. We are mainly,
But DW2 is evidence is clear regarding that.
he is from which village?
He from Narayan.
Huh? No, DW2 is from, not from Narayan, he is from Joljoli.
There is statement.
Or DW2 is from Naranggaon.
Narayan.
Naranggaon. Okay, yes. Mr. Sharma.
Lordship, only voter ID subsequent.
Mr. Sharma.
Yes, Lordship. There is no link at all, Lordship. To establish a link with his projected father, Lordship, even her projected father's name citizenship also doubtful because Lordship, as per her evidence, Lordship, Prosri was in 2018, Lordship, he was about 39 years, Lordship, and sometimes he was born in the year of 1979. And Lordship, so till 1979, his father at least available in the territory of Assam. But there is nothing, Lordship, not a single voter list has been placed, Lordship, where her father's name is appearing, Lordship.
At least till 1979, our father's name should have been there. That is the
Yes,
year of
Lordship,
of her birth.
71,
71, 72, whatever.
70, Lordship. And Lordship, only document placed by the proceedings NRC document which was issued by Jamaat Ulema in Hind, Lordship, which is not an authorized authority to issue the NRC certificate, Lordship. And Lordship, Lordship has already pointed out, Lordship, oral statement is not enough, Lordship. In Bijoy Das case as well as Noor Begum's case, Lordship, reported case, both are
Citation.
yes, Lordship, 2018. 3 GLP,
2018.
18 3 GLP, Lordship. 18 3 GLP, 118.
Name Vijay Das.
Bijoy Das, Lordship.
Para.
Para 17. And Lordship, another is 2023 GLT 347.
2023.
GL 2020 3 GLT 347. Para 6, Lordship.
Name.
Noor Begum.
NUR.
NUR BEGUM Noor Begum versus Union of India. And Lord, here regarding mother statement has been discussed, Lordship. And Lordship, one Gaubra of his her husband's village, Lordship, deposed before the tribunal. And Lordship, here, Lordship, what Gaubra has said, Lordship, DW3. I never met father of Opi but could know about their family.
Page.
Lordship, in LCR, Lordship, I am saying page 35, Lordship. I never met father of Opi but could know about their family at Narangao from the Gaubura of village Narangao, namely Hoburam Boro. And moreover, there are some other people at village Narangao known to me. I do not maintain any register with regards to birth and death of people residing under my jurisdictional village, and I issued Exhibit 10 from the base of my personal knowledge, Lordship. So Gaubura's certificate and evidence based on personal record is not enough to establish one's citizenship, Lordship. Regarding that, Lordship, several laws have been settled, Lordship. One of the citation, Lordship, regarding that Lordship, 1073, WTC 1073 of 2016, Lordship,
1073 of,
of 2016, Abdul Quddus, MD Abdul Quddus, KUDDUS.
hmm.
Lordship,
Opposition,
proposition, Lordship, may
date of the judgment,
date of judgment is 7/5/2018. 7/5/2018. And Lordship, para 15, I am relaying. Exhibit one is the certificate issued by the Gaubura on 2/8/2010. He certified that A. Quddus was son of late A. Kadir and that he was a resident of Boitamari village. Father was Putar of Lahorighat village. A. Quddus was born in Boitamari village but shifted to his residence to village Sarapathar village. Though the Gaubura deposed as DW2, he did not bring the official register or record to prove the contents of Exhibit Co. Therefore, the contents of Exhibit Co. 1 cannot be said to have been proved. It is tried that documentary evidence has to be proved on the basis of contemporaneous record and not on the basis of personal knowledge through oral testimony. From the documents as well as from the deposition of Gaubura, what transpires is that the certificate was issued without reference to any official record. So, Lordship, Gaubura's oral statement is not enough to establish one's citizenship. And apart from this oral statements, there is nothing to establish her link with her projected father or grandfather who existed prior to 1966 or since 1966, Lordship. And so, Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship. So, opinion may not be disturbed, Lordship.
okay, we'll consider. Anything else you'd like to add to Mr. Sharma? Madam, you'd be appearing as CGC. And N. Kolita for AI Ali. Naam likhe lo, huh? Eta naam thaki officer. We'll have it this reserved, okay? D. Chaudhary, then G. Sharma, Home, CGC, B. Sharma, State Council P. Sharma, Election Commission of India N. Kolita on behalf of AI Ali, Standing Council ECI. Hearing is concluded, judgment is reserved. Yes, Mr.
Yes.
Ahmed.
Impin order is stage 16.
60.
Superintendent of Police B. Nagaur refers the case
I think we put it that in reference is made 1166 to 25/3/1971. But tribunal declared the petitioner as a foreigner of 473. Page number of space 60. 60.
Reference to put this. Reference to
Inquiry report.
put this. Go. Inquiry to
47. Yes, sir. Before going through the judgment, you know, kindly see page 47, inquiry report. Bottom, serial number 18.
Page?
Page 47.
Yes.
Serial number 18 minutes. In this report, inquiry officer to make a specific remark of this findings whether the person is a 66 to 71 foreigner with reason. During inquiry, it appears to me that me is prima facie manner that the suspect who entered into India in 1960 happened in 71 experience. But in this case, Miller tribunal declared the petitioner as a foreigner of post 71. That cannot be. As per our license, that's what in the case of university.
Okay, we'll take a 5 minute break.
Not. That's it.
Petition?
2017 GLT 1065.
2017 2 GLT.
10. Santosh Das.
Paragraph?
14, 15, 16, 17. It's more than.
Yes, please read.
Para 14. Section 3 of the Foreigners Act 1946 empowers the central government to make order dealing with the foreigner in exercise of power conferred under Section 3 of the Foreigners Tribunal for 1950 was set. Order to deal with the constitution of the tribunal as per order 2 central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of the Foreign Act 1950 to a tribunal to be constituted for the purpose for this court is opinion. Order 1A also contracts of power on a registering authority appointed under Schedule 1 Rule 60F of the Citizenship Rules 1956. We have been informed at the bar that the power of the central government to make reference in terms of the delegated concern to funding of food. From a careful reading of the order to one of the what is a discernible is that the reference is made to a criminal document whether person is or is not a foreigner within the meaning of Section 2 of the Foreigner Tribunal. The tribunal to render is only a reference is made. Hearing this reference is made 1166 to 1971. That is tribunal. Without reference being made, tribunal cannot exercise its jurisdiction to opine that a person is or is not a foreigner. It is only when a reference is made as above the tribunal as a jurisdiction to render it opinion. Therefore, to our mind, tribunal would have to confine to the terms of the reference made with and accord and cannot go beyond the same. Admittedly, in this case, a reference was there the petitioner is a foreigner who illegally entered into India to from the Swiss territory during the period of 1/1/1962 to 24/3/1971. The tribunal was required to answer the reference either in favor of the state or in favor of the prosecution. If the reference was to be answered in favor of the state and it was answered rightly, so by the tribunal, the necessary corollary would be that petitioner is a foreigner belonging to 1/1/1962 to 24/3/1971. Therefore, in view taken by the tribunal that the foreigner at 1942 of the order can and the do not bind with the terms of the reference is not correct. 17. Accordingly, order dated so filed by the foreigner tribunal Iran in censor number would be modified as the reference would stand answered in favor of the state by opinion that the petitioner is a foreigner who illegally entered India from the Swiss territory during the period of conflict. In view of the submission, a declaration petitioner is given liberty to register his land as a foreigner of the state before the competent owners to register a regional registration officer. This shall be done within a period of 30 days from today.
Mr. Ahmed, there will be two issues.
Yes.
If you are agreeing with the reference, terms of the reference, going by the principles laid down in the case of Santosh Das, then we can, and we have not even heard Mr. Sharma. If they are agreeing, then we can pass a similar order. But at the same time, you are also at liberty to challenge the opinion as a whole.
No, my lord, I am, my prayer will be, my lord. petitioner-
If you are confining to that, then it will be easy. If
My lord, I am
Mr. Sharma is and that is the principle, from that process, but if you would have been at liberty to challenge the entire opinion that even from that period you cannot be declared, which you are not doing. Your instructions is to confine to the reference order, then it's okay.
My lord, in this case, my prayer will be, my lord, a petitioner may be chance to get registered, my lord, after.
Yes, Mr.
Other schools will be.
My lord, in this regard, lordship, I am just relying to decisions of this.
No, do you have anything to join so far as the principle laid down in Santosh Das is concerned?
Yes.
If that is the law which is holding the field, and Mr. Ahmed has very candidly has very fairly said that he would be satisfied if it's a registration order given, then we can abide by that and say that he would be foreigner from that period 66 to 71, and he gets himself or herself, he or a she, what is the name? He can get himself registered. Because he's not arguing
Yes.
that he's not a foreigner. He is saying that my stream should be 66 to 71 because that was the reference. As such, he is not challenging the outcome of the reference. He is only challenging that part of the opinion which says that no, his stream should be post 71. That is his nuance.
Yes,
Will be liable to be deported.
My lord.
If the stream is post 1971, will be liable to be deported.
Yes, my lord. And in between, my lord, a petitioner's name have to be deleted from the voter list for the 10 years. My lord. After 10 years is over, his name is normally included in the voter list. Then he will get the benefits of the other. Like that. That is this.
First, lordship, I am submitting Aziz Mia's case, lordship. What it has says, lordship, 2370/2023. WBC 2370/2023. Para 10 and 11, lordship, I am submitting, lordship. Clause 2 of the Foreigners Tribunal Order 1964 provides.
Aziz Bhai, how do you spell AZIZ?
Yes, lordship.
MIAH?
MIYA.
MIYA.
Alias Muhammad Aziz Mia.
Date of the order?
9/6/2023.
What does it say?
Lordship, just I am reading the paragraph, lordship. Clause 2 of the Foreigners Tribunal Order 1964 provides that The central government may by order refer the question as to whether the person is or is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. It is stated that the central government by an appropriate notification had delegated its power under Clause 2 of the Foreigners Tribunal Order 1964 to Superintendent of Police Border of the respective district to make any order referring the question on the citizenship of a person to a tribunal constituted for the purpose for its opinion. The provisions of Clause 2 of the Foreigners Tribunal Order 1964 makes it explicit that it is the Superintendent of Police Border who would be the authority to take a decision based upon the report of the inquiry or any further materials that may be available as to whether a person concerned is required to be referred to a tribunal for its opinion as to whether he is a foreigner or not. A reading of the provisions of Clause 2 of the Foreigners Tribunal Order 1964, as indicated above, also leads to a conclusion that the report of the investigating authority that may have been submitted as to whether the suspected person is a foreigner or not would be merely indicative in nature and cannot be said to have attained finality on the status of the suspected person as to whether he is a foreigner. From such point of view, we are unable to accept the submission of Mr. R. Ali, learned counsel for the petitioner, that because of the inquiring authority in the instant case. So, Lordship, here what it has said, Lordship, inquiry officer's report does not attain finality, Lordship. So, meaning thereby, Lordship, a tribunal can go beyond reference, Lordship. And Lordship, another case, Lordship, Rukia Begum Borhuya, WPC 2279 of 2021. Very long judgment, Lordship, regarding this aspect, Lordship.
2279
of 2021. RUKIA, Rukia, BEGUM, Borhuya, BARBHUIYA. And
disposal date.
disposal date, Lordship, 12/6/2023.
Paragraph.
Lordship, 7. And Lordship, 12, 13, 14, and 17. Whole judgment is important, Lordship. Just I'm.
It's a reported judgment?
It was reported or not, I don't know, Lordship, but reportable at the top it was written, Lordship. Yes. So, Lordship, para 7, which says, Lordship, from the reading of the provisions of paragraph 16 of the judgment in Phalani Bibi Subra, and this Phalani Bibi is based on Santosh Das case, Lordship. It is discernible that in the said matter, a reference was made as to whether the person concerned came into the state of Assam from the specified territory between the period of 1/1/1966 to 24/3/1971. But upon considering the materials on record that had been produced before the tribunal by the proceeding concerned, the tribunal was of the view that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971. In these circumstances, the tribunal declared the person concerned to be a foreigner by arriving at a conclusion that the Foreigners Act 1946 or the orders framed thereunder do not bind the tribunal to the terms of the reference. The said view of the tribunal was assailed in the writ petition in Phalani Bibi, and while adjudicating the said writ petition, the court had formed the views as provided in paragraph 16 thereof, which are extracted herein above. A reading of paragraph 16 of the judgment in Phalani Bibi makes it discernible that the court had gone into the question that the tribunal derives its jurisdiction to answer a reference under order to 1 of the Foreigners Tribunal Order 1964, and Therefore, it cannot answer any question which may be beyond the reference that had been made. As the reference was made in Phalani Bibi Supra as to whether the person concerned had entered the state of Assam from the specified territory between 1/1/1966 to 24/3/1971. Therefore, the tribunal could not have answered the reference by holding that concerned person had entered the state of Assam from the specified territory on or after 25/3/1971. Conceptually, we are in agreement with the view that Phalani Bibi Supra that a tribunal cannot answer a reference beyond the reference that has been made to it. But at the same time, we are also required to look into as to what would be understood to be a reference made to a tribunal to answer the question. We are required to look into the provisions of Rule 2(1) of the Foreigners Tribunal Order 1964, which is extracted below. Constitution of Tribunals. The central government may by order refer the question as to whether the person is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. A reading of Rule 2(1) of the Foreigners Tribunal Order 1964 makes it discernible that the central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal constituted for the purpose. The statutory provision of Rule 2(1) makes it explicit that the reference to be made by the tribunal would be the question as to whether the person is or is not a foreigner within the meaning of the Foreigners Act 1946. Section 2A of the Foreigners Act 1946 defines foreigners to mean a person who is not a citizen of India. In other words, going by the meaning given by the expression foreigner under Section 2A of the Foreigners Act 1946, a reference made to the tribunal would be as to whether the person concerned is a citizen of India or he is not a citizen of India. To understand the concept of being citizen or a foreigner in respect of such category of persons who entered the state of Assam from the specified territory, which in other words would require an appreciation of the provisions of Section 6A of the Citizenship Act 1955. Section 6A of the Citizenship 1955 is extracted below. Lordship, 6A was discussed in this paragraph.
Yes, sir.
Then para 12, Lordship, I am reading. A reading of the provisions of Section 6A makes it explicit that it is a special provision as to citizenship of persons covered by the Assam Accord, and the core provision of Section 6A are that person who may have entered the state of Assam from the specified territory prior to 1/1/1966 shall be deemed to be citizen of India from the 1st January 1966. The further provision is that such persons who entered the state of Assam from the specified territory after 1/1/1966 but before 1971 from the specified territory and has been detected to be a foreigner shall register himself with the foreigners registering authority of the district concerned, and upon having been registered shall be debarred of any voting rights for a period of 10 years, but otherwise retaining all such other rights that a citizen of India may be bestowed with under the provisions, and further that upon expiry of the period of 10 years, even the voting rights would be restored back. In the case of persons who had entered the state of Assam from the specified territory on or after 25/3/1971, such persons are to be declared there as foreigners. In view of the provisions of Section 6A of the Citizenship Act 1955, Clause 2(1) of the Foreigners Tribunal Order 1964 would now have to be understood that once a reference is made, the reference would be whether a person concerned is or is not a foreigner, meaning thereby whether the person concerned is a foreigner who had entered the state of Assam from the specified territory on or after 25/3/1971, or he is a person who belongs to any of the other categories, that is a person who entered the state of Assam from the specified territory before 1/1/1966 or between 1/1/1966 and 25/3/1971. No other meaning can be attributed to the reference under Clause 2(1) of the Foreigners Tribunal Order 1964. That is, whether a person is or is not a foreigner within the meaning of Foreigners Act 1946. We further take note that even if a reference is made by setting up a question whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, the reference would have to be understood to be a reference under Clause 2(1) of the Foreigners Tribunal Order 1964. That is, as to whether he is a foreigner or not. If the reference is worded whether the person concerned is a person who had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, in order to arrive at any such conclusion that the reference itself is faulty inasmuch as the decision of the tribunal upon the materials on record would be that the person concerned had entered the state of Assam from the specified territory on or after 1971. In such circumstances, the only situation that can be envisaged is that the tribunal first arrives at a conclusion of its own that the person concerned had entered the state of Assam from the specified territory on or after 1971, meaning thereby that the reference itself has been answered by the tribunal. After having answered the reference, it would be an inconceivable situation that merely because the reference worded whether the person had entered the state of Assam from the specified territory between 1/1/96 and 25/3/1971, it has to be referred back to the referral authority to make a fair reference, now putting up a question whether the person concerned had entered the state of Assam on or after 25/3/1971. In such situation, as the matter would have to be referred back only after the final decision has been arrived at, and now if the reference is again made with a corrected expression in the questions framed, the same may lead to further complications that the subsequent reference would be barred by principle of res judicata. Inasmuch as it would be a subsequent reference on the same issue between the same set of parties where an earlier decision had already been arrived at. It is noticed that in Phalani Bibi Supra, the aforesaid aspect of the further implication of a corrected reference being again made had not been gone into, and from such point of view, it can be said that view taken therein would be par inquirium of the further consequences of a fresh reference being made. Lordship.
So has it impliedly overruled Santosh Das?
And
It cannot be
directly,
overruled.
directly
It's a
not.
there's no question of overruling. It's a coordinate bench.
Yes, Lordship, directly it was not overruled, Lordship. Then para 14, 15, 16.
No, coordinate bench cannot overrule, but coordinate
Yes.
bench can cite some
Distinguish.
Supreme Court judgments.
Then Lordship. Para 17 is more important, Lordship.
Yes, we'll come back.
Para 17.
We'll come back.
Lordship.
But one thing my brother has just pointed out, if the reference is for a particular stream, that means he is on a burden to discharge a burden that he does not belong to that stream.
Yes.
Now, if you make it more stringent, won't it cause prejudice to him?
Lordship.
He was to show that he is not from 66 to 71, but from before 66. But he fails in that. But he is made to be after 71. The
Lordship.
consequences are different totally.
Lordship. Lordship.
So, we'll again see this Aziz Mia again and Rukia Begum.
Rukia
again.
Begum, Bhuya is more important, Lordship.
Sister, good afternoon. You are there?
Yes, yes.
We have dismissed the writ petition. Yes.
My lord. Just I am reading, Lordship, para 14, 15, 16 and 17, Lordship.
No, we have understood your,
Yes.
you are relying upon Aziz Mia and Rukia Begum.
Yes, Lordship.
We want to know from you whether if there is a conflict of two coordinate benches and what would be our correct course of action.
Yes, then that was discussed in para 14, Lordship. Para 14, 15, 16 and
Santos has been discussed.
Yes, yes, Lordship.
No,
Yes, Lordship.
Oh,
Just
no,
I am
that's not the one.
reading para 14, Lordship. Mr. D. Mojumdar, learned additional Advocate General. Assam has also placed reliance upon the provisions of the Supreme Court rendered in paragraph 13 of the judgment in state of UP versus Ajoy Kumar Sharma reported in 2016 5 SCC 289, which is extracted as below. Time and again, this court has emphatically restated the essentials and
Has it been reported? My brother was asking. Has it been reported? This one?
Must
I have to search, Lordship, but
Might have been,
at the top,
likely.
at the top, it was written as reportable.
Search.
Step one is confirmed.
Para 13 of the state of UP versus Ajoy Kumar Supra Lordship, that was quoted, Lordship, in this judgment. Time and again, this court has emphatically restated the essentials and principles of precedent and stare decisions, which are a cardinal features of the hierarchical character of all common law judicial system. The doctrine of precedent mandates that an exposition of law must be followed and applied even by the coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. That is to say that a smaller and later bench has no freedom other than to apply the law laid down by the earlier and larger bench. That is the law which is said to hold the field. Apart from Article 141, it is a policy of the courts to stand by the precedent and not to disturb the settled point. The purpose of precedents is to bestow predictability on judicial decisions, and it is beyond a cavil that certainty in law is an essential ingredient of rule of law. A departure may only be made when a coordinate or co-equal bench finds the previous decisions to be of doubtful logic or efficacy of, and consequentially its judicial conscience is so perturbed and aroused that it finds it impossible to follow the existing ratio. The bench must then comply with the discipline of requesting the Honorable Chief Justice to constitute a larger bench. A reading of the provisions of paragraph 13 of the provisions of the Supreme Court in Ajoy Kumar Supra makes it discernible that the Supreme Court had emphatically restated the essentials and principles of precedent and stare decisions, which are a cardinal features of the hierarchical character of all common law judicial systems. The term stare decision is defined in Black's Law Dictionary to mean the doctrine of precedent under which a court must follow earlier judicial decisions when the same point arise again in a litigation. We are in the complete agreement with the principles of the precedent and stare decision that the court must follow the earlier judicial decisions when the same point arise in a litigation, but at the same time, it is also an accepted principle of law that the doctrine of per inquirium is an exception to the doctrine of stare decision. The doctrine of per inquirium is defined to be judicial decision which was wrongly decided because the judge or the judges were ill-informed about the applicability of the law. In the instant case, when the decision in Phalani Bibi Supra was rendered, the further technical complication that may arise upon a fresh and corrected reference being made that it may be barred by principle of res judicata was neither urged upon nor was gone into by the court. The question whether the reference is faulty or not can only be determined after there is a decision being rendered that a person concerned entered the state of Assam from the specified territory on or after 25/3/1971, whereas the referred question was whether he entered the state of Assam between 1/1/1966 and 25/3/1971. In other words, the conclusion as to whether the reference is faulty or not can be arrived at only after the final decision has been rendered on the materials being produced, and therefore, as a decision had been rendered upon the materials being produced, the same issue, if again referred back with any correction in the wordings in the reference, may invoke the principle of res judicata, that it cannot be referred and answered again, as it would be subsequent reference on the same issue, which is between the same parties and was decided in a prior proceeding. In these circumstances, we are of the view that principle of parencurium would be applicable in the instant case rather than principle of stare decisis. In view of above, the principle of parencurium is more applicable rather than it being the principle of stare decisis. The principles laid down in paragraph 13 of Ajay Sharma Supra can also be answered accordingly, that the earlier decision in Phalani Bibi Supra needs to be further clarification, to the extent that if the conclusion as regards the faulty reference can be arrived at only upon a final decision, it would be in the interest of all the parties to have the final decision being converted to an opinion rather than to undergo the technicality of returning the reference, having it corrected and decided once again. From such point of view, we are unable to agree with the order dated 25/1/2019 of the tribunal in FT4 so and so, Lordship. So, Lordship,
This was a conflict between two equal benches, or it was only the division bench, or judgment is obviously.
yes,
binding,
Lordship.
right?
Division bench judgment.
Division
Santosh
bench.
Das was division bench judgment, Lordship.
And the other one.
Other one also division bench judgment.
So according to this narration, which of the Honorable Supreme Court, that if there is a conflict between two coordinate benches of equal strength of the High Court,
Yes,
then what is the way forward?
yes.
Because in the case of Supreme Court, my senior brother Pamit, in the case of Supreme Court, recently, as you know, there was a difference with regard to Vihan Kumar and Darshan, right? So in that, the Vihan Kumar, the judgment of Darshan seemed to depart from the judgment of Vihan Kumar, and our division bench is referring to Pranay Sethi, an insurance law, said that the earlier one point of time has to be followed. If there's a conflict between two Supreme Court judgments where quorum is same.
Yes, Lordship. Here, Lordship.
In High Court, the same principle won't come. Just.
Yes, Lordship. Here, Lordship. In para 15 and 16, Lordship, it was discussed clearly, Lordship, that Lordship, if Lordship, in para 17, Lordship, if earlier said some law has, if Lordship, some law has not been discussed in the earlier decision, Lordship, earlier decision passed by Honorable High Court, then Lordship, it was Lordship, if some settled position are not discussed in the earlier judgment, Lordship, then it would be called as par inquirium, Lordship. So, Lordship, in this case, Lordship, I think, Lordship, if we follow this judgment, then I think, Lordship, tribunal is not bound to confine in the stream, Lordship, between 1966 to 70 or after 71. After trial, Lordship, tribunal can come to a conclusion that, Lordship, person concerned is falls under the category of that particular stream or
Another stream.
Another stream, Lordship.
Unlike what is said in Santosh.
Lordship.
Santosh, it's been said that tribunal is bound by the terms of the reference. Anyway.
Otherwise, Lordship, if we go to the petition, Lordship, then Lordship will kindly see only 1966 voter list is there, Lordship. on the basis of 1966 voter list lordship and some land documents lordship, tribunal cannot come to a conclusion that person concerned is lordship falls under the category of that particular stream lordship. So after trial lordship on the basis of materials available on record lordship, tribunal come to the conclusion that that person concerned is falls under the category of post 71 stream lordship.
No, Mr. Sharma,
Okay.
under this present case and the discussions which we are making,
Yes, Lord.
the reference was for a particular period, stream,
Yes, yes.
66 to 71. The reference has been answered that he belongs to the post 1971.
Yes, Lordship.
Mr. Ahmed is trying to make out a case that the tribunal cannot go beyond the reference.
Reference.
And he is not aggrieved that if an opinion against him is given so far as 66 to 71 is concerned, he'll get himself registered.
Yes, Lordship.
And therefore, he is asking that though the opinion can be against him, it should be within that period, 66. For that, he has given a concession. But you are arguing that the opinion is not bad.
Yes, Lordship.
It is within the competence of a tribunal to give an opinion despite a reference being made for a particular period.
Yes, Lordship.
Whatever is the period, if the tribunal finds that he is not being able to prove
Yes.
his stay within that period, then even post 71
yes,
it may
Lord.
given. That is your case.
Yes, Lordship.
If you are pressing on that, then we have to give. See, we have not made up our mind. We have to discuss. We have to adjudicate the issue. Then, if that is your case, we have to give another chance to Mr. Ahmed to argue that even if he concedes and if we are agreeing with you, post 71 is okay, then he has to be given a chance that it's not a case of post 71.
Yes, Lordship.
In this case, my learned fields, argued that have only voter list 66, which is absolutely not correct. It's not permitted voter list.
Just a minute. If we do not agree on the binding precedent, we have to show the No, not for that thing. No, see, no, you have to follow, you have to trust it, but this Rukia has taken care of Santosh. It is not that Rukia has been pronounced by ignoring people. Rukia has taken into consideration Santosh, distress, means that it is current for him. Foreign can be lawly law. Support that then, support that then. We don't know how to deceive of correct. One is the earlier point of time that is not correct. The correct question is which the fact which gas which your point should be different. Actually, they have discussed earlier that property not do very good. The hand project. Then there shall be a big.
Two 2023.
It's going by this law. The tribunal has flexibility to jump the stream in the process of adjudication. Right?
Yes.
That's the final result. And if this tribunal order is upheld, he would be liable to be deported, right? That's
Lord,
1971.
Yes, yes, Lord.
Then we look into the merits, whether if on prima facie I would not find that the 71 opinion is not sustainable, then otherwise he is considering to the effect 66 to 71. Let us see for under what are the materials for which this post 71 has been decided. Let us see what materials.
Prior to Miller, in this case Miller, a charge is framed under section, under Miller 66 to 71 Miller.
No, we are not on that. Let us see the 71.
Yes.
That part will come later.
Voter list 1966.
Page
Of page 16.
16.
16. Barney is page 17.
Is it I get?
And in the inquiry matter, as per inquiry report, petitioner submitted voter list 66 and 77. Except in the reflected.
This is a voter list of which year? 1966.
Abdul Mojid. Village is Sam Miller, Bhehuguri Gaon.
What is the name of the proceedee?
Proceedee is Miller, Mukles Uddin.
Abdul is his father.
Yes, Abdul Mojid is the father.
Father, then
Then Miller pays 18 Miller, one Ramabundi Miller in the name of father Miller. And other Miller.
80, page
1.
18.
Particular is paid 1.
Where is the vernacular?
Particular is paid 19.
Hmm.
And next page 20. A particular Upopoti Hormata Saragami Chita, trying to get in Hukumate, Corridor Trade, Ludwija Ekpata Nalasa Mati.
Serial number?
Serial number 5.
5. So it is 9 at 19.
Yes. Serial number 5, Abdul Mojid.
Yes, Abdul Mojid.
Upopoti Hormata, page 19, bottom right side.
Yes.
Upopoti Hormata Saragami Chita, trying to get. In Tarimut, Corridor Hutre, Ludwija Ekpata Nalasa Mati. Sarinam Patadar Abdul Hamid, Abdul Mojito Logo, Ali Hussein, Aro Abdul Rahman Namdari. Next page,
What is the date of this?
date is 1986. The 23/4/1987. Page 19, right side bottom.
By way of purchase, Lordship. It is not by inheritance.
Name of father. Father had purchased.
Yes.
Yes, Lordship.
Yes.
Next page is 21. Then the will be articles of Pisa 1957-58. Serial number 6, Abdul Mojid. Banipur page 22.
Itao 57, 58.
Yes. Banipur page 23. Village Bhehuguri, which is reflected in the voter list 1960.
So this is in the father's name.
Yes, father.
Your connection with your father.
Yes, on the 1987 voter list.
Page
On the 1985 voter list.
Page
31.
31.
Yes. Banipur page 32. And the 6th. Moza Shilpupuri Thana, Jila Naga, Moza Shilpupuri Thana, Lukilbeta, Gao Bhehuguri, which is reflected in the 1957 also in the 66 voter list also. Here is Abdul Mojid, father, Jamana Khatun, Mukul S. Miller, serial number 490, at the age of 25.
This is the first time. What was the age of Minimum age of voting at that time, 18 or 21.
At that time, it was 21.
Mukhlis Mozit, not Mozid, Mozit.
Abdul Mojid, actually, Abdul Mojid, JIT something. They are treated to me, well, written by the official of the election official. Otherwise, village are same. Usually in 1966, 1967, and other documents in 1984, 87.
But Mr. Ahmed, your father, Abdul Mozid or Mozid, let us say, assume that for the time being that is the same person. In 66, he was aged 38 years.
That is the difficulty of age.
In 66, he was aged 38 years. In 85, he is aged what?
85 years is not.
50. 50. Age should have been how much?
How much?
Decreasing here.
Then 38 is not 50.
38 should have been become at least 58, 57, 58. Yours has come down to 50.
And Bhutan is 1997. The name of father.
And the name of your grandfather was Abdul Mozid, son of Rahman.
Abdul.
Here it is Rahman Ali.
That is the discrepancy occurred in the voter list, which is done by the official authority. And here discrepancy of some discrepancy in the damage, a person cannot be correct for me. So many judgments here our case.
Only one Kematullah Kefatullah. That is that we have dealt with. Kematullah Kefatullah is a old judgment we have dealt with.
In the case of Motiur Rahman,
In the grandfather's name, instead of F, M had come. Under those circumstances, Honorable Supreme Court.
Here is 1985, Abdul Mojib T. Here is if we listen in English, then can be ZIT.
Earlier,
Earlier, Abdul Mojib, all the documents.
where is it to? It is do. It is not to.
And do.
It is do, not to.
Yes. In other documents, Abdul Mojib is stated. One this
Judgment.
1952, page 24.
Mojid D. Mojid. MAZIT. JIT.
And this is what, 97 voter list,
The 97 voter list is
28,
years.
What is this?
Miller, Sam Village,
yes.
Abdul Mojib. Abdul Rahman.
He was 58 or 54 or 58.
58.
And in
And voter list 2005. Place.
in 97, where are you?
They, not in the only single voter list. That's why some problem is there.
No, we are more interested in your voter. You said that you came into the scenario in 1985, aged 25 years.
Yes.
Where are you in 97?
In the voter list of Mukhlis Malot is 33. Voter list of 1997.
33.
33, 34. 97 voter list. Two 2005, 2011, 2016 also.
Kuntu. 97. Quran. Is it Quran? During the time of argument, let's go. Can agree upon that.
We'll have this on another day. We'd like to have a Rukia, this
Yes.
Begum will.
Yes,
can have this
it
day
is,
after
it is
tomorrow.
reported, Lordship. Reported.
Reported. You should have told us before.
2023 for GLT 1208.
23.
23 for GLT
4
1208.
GLT.
Yes, Lordship. 1208. 1208.
1208.
1208. No, that's it. And Aziz Mia is 2023 for GLT 246.
Aziz Mia has also reported 2023
for GLT 246.
4 GLT
246.
We'll have it day after tomorrow.
Got.
Milord, item number 9 and 10.
Just a minute, just a minute. Part 3A M. Ahmed Learned Counsel for the petitioner. Also heard 3 so and so, huh? So while 3 Ahmed, the Learned Counsel, has based his challenge upon our decision of this court reported in 2017 within bracket 2 GLT 1065 Santosh Das versus Union of India, wherein it has been laid down that a tribunal cannot assume jurisdiction without there being a reference, and such tribunal is to confine itself to the issue of the reference and cannot traverse beyond the same, comma, Sri Sharma, the learned Standing Council Home Department has submitted that the aforesaid proposition has been explained by a later decision of a coordinate bench in the case of Rukia Begum versus Union of India. Rukia Begum Borbhia versus Union of India reported in 2023, 4 GLT 1208. Full stop. He has also relied upon another decision of a coordinate bench reported in 2023, 4 GLT 246, Aziz Mia versus Union of India. Full stop. Para. In view of the above, comma, consideration of this matter is deferred with a direction to list the same on Wednesday.
Friday, Miller? Friday.
Friday may be difficult.
Friday, sometime I may be, Friday, Miller.
Friday?
Huh?
Friday ki 21, yes, okay, Friday.
Miller, item number 9 and 10, Miller.
Should be dismissed. We'll do it.
Should not be taken up today.
No, it didn't matter.
It did matter, Miller, then Miller, matter may be taken up next week, any day.
No.
Miller, I have to go through some judgment, Miller, in this case.
It didn't matter. So
In
if
the-
you have,
Miller,
for the
in
last
this
6
case,
years, 7 years, if you have not found any
Miller,
judgment,
yes,
you are
yes.
not going to find in one day.
Miller, one of the case, Miller, proceeding is dropped by the ERO, but subsequently referred to the tribunal.
We'll take up whatever.
Day after tomorrow, then Miller.
Why day after tomorrow?
Oh, Miller.
Tomorrow.
Tomorrow.
Tomorrow. We are not going to, don't ask adjournment in 2018 matter. We are not going to adjourn.
Tomorrow, Miller.
If somebody is ill or something, then matter is
Yes,
different.
tomorrow.
Now, don't say that you are ill now.
No, I am taking. Tomorrow, Miller.
Okay, tomorrow. 9 and 10, on a request made on behalf of the petitioner. List tomorrow. List
9
again.
and 10.
List 9 and 10.
God bless.
Okay.
Item number 19 matter.
Lordship, kindly see last order 29/10/2025. The Honorable Court directed the exhibit document be properly signed by the tribunal.
Has it come
Yes, Lord.
after signature?
Yes, sir.
Is there any report?
Lordship, kindly matter fix next week. My senior will appear in this case.
Lordship. I may allow to return back the LCL.
It was with you. You had got
Yes,
it.
Lordship, yes.
It's done by you or by the registry?
Lordship, through my, I have taken this test, Lordship.
Pursuant to the order dated 29/10/2025 passed by this court, comma, the records of the tribunal was returned through Sri G. Sharma, the Learned Standing Council, for affixing the signature of the learned member in the exhibited documents, full stop. Shri Sharma, the learned standing counsel, has informed this court that that all such exhibits, or that the signatures of the learned member have been affixed in the exhibits, and the original file has been returned to the court. Full stop. Para. The matter is accordingly directed to be listed for admission next week. Next week, madam. Item number? Mr. Sheikh? Sheikh was here. Am I Sheikh? Recorder, he said. Recorder, sir. Oh. None appears for the petitioner on call, whereas the learned counsel for the respondents are present. Pursuant to the order dated, pursuant to orders passed earlier, comma, the records of the learned tribunal have been received. Full stop. List for admission hearing after a week. Full stop. It is however made clear that in case of further non-representation on behalf of the petitioner, comma, appropriate orders would be passed by this court. Mr. Mishra.
As per the earlier order, madam, instruction was sought for from the central government, madam. Regarding that, my case was rejected, madam, on the ground of my the ground of my lord, is refugee certificate. There was a question, madam.
Lordship, before my friend starts, your lordship, I'd like to, instruction was sought from, lordship, regarding the availability of that certificate. I've informed the Ministry of Home Affairs Department, your lordship. They are still couldn't trace the certificate, lordship. They are still finding, lordship. I further seek a 4 weeks time, your lordship. It's a huge department, your lordship, and it's a certificate of 1953, your lordship. They are still unable to trace it, your lordship. They are seeking some more time to.
You're under some interim of protection.
Yes, madam.
What about the aspect of CAA here? Will it be applicable?
I think Lordship, it will be applicable, Lordship, because
My lord, the,
Can I will CA thing?
my lord, the case is here, they my lord, myself and my sister, both of us were received notice from the court or tribunal, my lord. One from Kamrup, one from Morigaon. The Kamrup has declared, Kamrup, my sister was declared as Indian on the basis of the document which is under question now.
Okay.
Now, that record was called for from the court on the earlier round of litigation. And court, after being perusal of that, has sent back this matter to the Morigaon tribunal. Here, dear my lord, I have placed this document of 1953, my lord. This refugee certificate of 1953 and 1965 voter list shows my father's name. That was admitted.
No, we are not on that, Mr.
Well, that is there.
Mr. We are on the CA benefit.
I have to see, my lord.
You seek the instructions, you may get some benefit,
I have to see him.
like the other cases.
Yes, Lordship.
While Mr. Das will be given time to obtain that
Yes.
instructions, you also seek instructions from your client.
Yes.
You go. Heard Sri M.K. Mishra, learned counsel for the petitioner. Also heard Sri so-and-so, no? Sri D.J. Das, learned CGC.
For 1 year.
Learned CGC, prays for some more time to obtain the necessary instructions. Full stop. List after 4 weeks. Para. In the meantime, Sri Mishra, the learned counsel for the petitioner, would also seek necessary instructions with regard to the option with regard to taking with regard to the availability of further options under the CAA.
Lordship, my name may be reflected in the.
Yes, reflect the name of Sri DJ Das, that is CGC, may be reflected in the call list.
Much obliged.
May I please your Lordship? Lordship, kindly pass over the matter for time being.
Time being,
Yes, Lordship. English Council is on next.
Report. Report. Who, Mr. H.R. Chaudhary?
Yes.
Okay, ask him to come.
Yes, your lordship. Such a petitioner before your lordship was declared foreigner by the impugn order dated 27 March 2025, my lord. This is at page number 38.
Report this, sir. Create.
Yes,
Third.
madam, 38.
Yes, please read.
Yes, my lord, my humble submission is that, my lord, in the voter list of 1989, the petitioner's name along with the father's name has appeared, which was ignored by the learned tribunal, my lord. This is at page number 20, my lord.
Which is that exhibit? Exhibit what?
My lord. Exhibit 3, my lord.
3.
3.
Page? Is it a part of the writ petition?
I have just annexed exhibit, my lord.
What is your name?
Well, my name is Abdul Rahman.
Abdul Rahman.
My-
What is the name of your father?
Abdul Hamid.
And prior to this, where are your voters list?
My lord, my father's name was there in the prior.
No, no, here in 1989, what was your age?
30, my lord.
30. So you must have definitely voted in the at least two earlier elections.
What is the name figure? We must have figured.
That record I
It is
have,
not
my lord. And my lord, as per verification officer's report also, my place of birth is Khonamo. And whether migrated to Assam, it is stated no.
This is that page,
Page number 28, 15 column,
28.
28.
Madam, tell us what are your documents? We have seen there's a voters list of 1989, which has your name,
Yes.
son of Abdul Hamid. And in that voter list, your father's name is also there. And you have also exhibited two more voters list. One is 66, having the name of your father
Father.
at page 16, and page 18 is 1971.
Yes, my lord.
Father, 33 years. What are the other documents? So 89 document is the document where you have a link with your father. And at that time you were aged 30 years of age, 30 years old. You do not have any earlier voters list.
No, but right now I do not have, my lord.
Abdul Hamid.
You said that this 1989 voter list have not been taken into consideration.
Yes, my lord.
Yes, Mr. Sharma.
Lordship was taken into consideration, Lordship, in para 33, Lordship. Exhibit 1, 2, and 3 are the copy of the voter list of 1966 of 78 Balipara LSC, 1971 and 1989 of number 74 Rangapara LSC in the name of so Lordship. After perusal of these documents, it is found that, so Lordship, it was taken into consideration, Lordship.
No, what about the name of the petitioner?
The Feroz is found vote in two different constituencies. This is what we.
And Lordship,
Both the voters list were found to be doubtful according to
Yes,
this
yes.
para 4.
yes, Lordship, yes, Lordship. Different constituency, Lordship, and Lordship, one important aspect is Lordship, age discrepancy is also there, Lordship, regarding.
No, there is no discussion at all with the 1989 voter list, qua the fact that the name of the petitioner is projected to be there. There is a name, Abdul Rahman, son of Abdul Hamid. There is no discussion.
Named Abdul Hamid and
Page 21.
Page 39, Lordship.
Abdul Hamid.
Yes, 39.
This one.
And therefore, this tribunal believed that the person reflected in the voter list of 1966 in 1971 is not same person. I could not find the link, Lordship. I could not find the link, Lordship, here in this place.
Which link? Link with the father?
Yes, Lordship.
Page 21.
21.
Mm.
Before.
Okay. Petitioner has to prove that Lordship, this Abdul Hamid and 1966 Abdul Hamid are same and one person, Lordship.
That is a different argument.
Yes, Lordship.
But there has to be some discussion that this petitioner's name is not. Why is it there? If you are not if you are discarding, you have to give some reasons. Paragraph 3 discussion. at page 30,
71 list.
39, paragraph 3 at page 39, there is no discussion of 1989 voters list at all, so far as the name of the petitioner is there. He has mentioned, no doubt,
89.
89 list. What is your take, what is your response to change in the constituency from Balipara to Rangapara?
It
Have
is
you-
one and the same person.
Constitution cannot change automatically. It is not the case that Balipara has become Rangapara. It's a different constituency. How have you explained that? Has it been explained, Mr. Sharma?
No, I think not. I'm going through the written statement, Lordship.
My lord, in an extra one, that is item, that is page number 16, my lord.
1-6.
Yes, my lord. It is 78 number Balipara electoral and PS is Rangapara only, my lord.
No, the LSC.
Yes, LSC is Balipara, but
Yes,
police
it's same.
station is Rangapara only, but here in page number 18, my lord, annexure 2, that is also PS Rangapara. And
No, you are not on the PS.
Yes,
and
it's same.
LSC.
We are on the LSC.
Well,
LEC is different.
16 is a Balipara electoral roll, 18 is a Rangapara electoral roll. How have you explained in your written statement? Did Balipara become Rangapara?
After 71 to 1989, Lordship, there is a huge gap, Lordship.
Almost 20 years gap, 18 years gap.
Yes, Lord.
No voters list.
No, not a single document, Lordship.
Voted after 18 years,
Yes, Lordship.
less than the last one.
My lord, in both the electoral roll of 1966 and 71, their house numbers are also same, my lord. Only just constituency is different.
Their village, according to you, is it a case of village, that particular village undergoing a change in the constituency?
Constituency is same, village is same.
Where is it stated that this village was inducted in another constituency?
Upper LAC.
Para 8 of the written statement. Copy আছে নেকি? 25 নম্বৰ পেজ। 923. I think, Lordship, in statement made in paragraph number 8 of the written statement, Lordship, it is not true because Lordship will kindly see page 25. This is
20?
25.
25.
Vernacular
Of-
page of
Wait.
writ petition, Lordship.
25.
This is report regarding death, Lordship, given by concerned Gabura. Here village was written as Phonamuk.
So,
What do you want to show from this, Mr. Sharma?
Lordship, ইয়াৰ দ্বাৰা প্ৰতিবেদন দিয়া হয় যে লেট আব্দুল হামিদ পিতা চুৱেনছো হাং খনামুক
Non-K Patgaon.
yes, Lordship, that he was died on death, Lordship, he is not eligible death, that he was died on some particular death, Lordship.
death certificate.
Yes, death certificate given by Gaubhra,
No.
and it was not proved, Lordship. That much only.
Now, how does it make any difference?
Because Lordship, here it is said that Lordship in death, that be it mentioned here that the village number 1 Miripothar was falls under the village Khonamuk at first, but later on after census made by the government, the village Khonamuk divided in separate villages such as Baligao, Bukagao, number 1 Miripothar, etc. So Lordship here 1966 village is Khonamuk, Lordship. After then Lordship 1971 is also same, and after that Lordship, after a huge gap Lordship, after 1971 Lordship discrepancies has been arises Lordship, and it was his proceedings name reflected along with his father in a different in a voter list which is of different constituency and different village Lordship.
The 1981.
Yes,
89 one.
89.
On the face of it, does not seem to be sufficient materials to explain because for the understanding of the court as
Yes.
to how the constituency changed. It might have been changed, but materials. Isn't how Balipara, he was in Balipara.
Yes.
He was in number 1 Miripatha.
Yeah, the same location.
And I have
was-
searched in the Google, my lord, where here you found that Khanamuk is just adjacent to number 1 Miripatha, my lord.
So it was the area,
Yes, same.
the area changed to another LAC,
Yes, my lord.
but you don't have any.
Not the same village. But not the same village Lordship.
Not the same village.
Madam, see, the burden is upon you. You have
Yes.
produced certain documents. If there are inconsistencies in the documents, you have to explain those inconsistencies. It may be a case that a particular village was in one constituency, there was a delimitation exercise, and this village goes to another constituency. House number remains the same. It can be a case that you have shifted from one village to another village. Coincidentally, the house number is the same, the constituency changes, village changes. Now we find that there is a change in the constituency. You said the house number is the same. Thereafter, you do not have any explanation. Whether there is delimitation exercise, change of constituency, change of village, you are totally silent. Under those circumstances, how do you proceed? How do you discharge your burden? Section 9 burden is very heavy,
Very heavy.
entirely upon you.
It's a tough burden.
My lord, since in the voter list of 1989, my name along with my father is there in the village Miripatha, my lord. And which is also the same constituency, 74 Rangapara constituency, my lord.
1989.
Except the 1966, my lord, since 1971, my LSC was same, my lord.
But you come to the voter list of 1971. What is your village? Village is Khonamuk.
Khonamuk, my lord. My lord, it was stated in my written statement that earlier it was Khonamuk, but then it is divided into Miripatha number 1, Bukazan and Baligaon, my lord.
Where have you stated? Page.
32, my lord. At paragraph 8.
Nineteen eighty-nine voter list is also there. It is also next.
Yes, yes, page 21,
89,
page 21.
96, sorry, 96. Mention the
96 is not there.
96 voter list
Yes, 96 is there.
along with his father is there.
And here village is Baligam Bukagar number 1 Mirzapatha.
It is at which page?
22.
Page 22.
There.
Hmm. 90?
1996, my lord.
Exhibit what?
No,
Hmm? Where is the exhibit?
56. Is it exhibit? Oh, it's not exhibited. I think.
It is not exhibited, my lord.
Then
It should have an exhibit.
how do you bring in a new document? Report of 90. Breaking.
So Sharma, what is this para 6 of the opinion? Reference to a birth certificate. Is it essential to exhibit a birth certificate?
Para 6, Lordship.
Para 6.
Exhibit.
Police verification report of 1966.
When the Cockburn police is wherein he claimed that he was born in village Khanamuk, India, 1966.
This was found to be Khanamuk. 1966, but
something to protect.
there's a reference about not having a birth certificate. When you
So this part is
And see, kindly see page 22 and 23. 23, these are so serious matters. 23 is the vernacular. Can you even? 23, can you read 23? Can you read 23, madam?
very, very good. We are reading the translation.
These matters we always look for the original. It was firstly not exhibited, not proved, not produced. Now you have put it in the High Court in the writ petition and closed. Can you read this?
This was an important document for him, I think. 96. Anyway. Numbers of pre-71.
This was instituted in the year 2025. See the notarial this stamp, the date 2010. Left side, left side.
Just take it. Stick in that time. It is still in total.
And how is it that this contains the stamp of the bench assistant of the tribunal?
No, it is not exhibited, my lord.
Huh?
As per my instruction, it is not exhibited.
Yeah.
Report of 9. It was not even produced, and how do you get the stamps?
That's fine.
First notary is of 2010. The certificate is of 2004. Four or nine, what is this? 4. Who does this? Who does it?
You said, madam, that the house number is the same. The tribunal had said that LAC number, of course, it is on record, it's two different LAC numbers, LACs, but house number found discrepancy in the house number, but your condition was the house number is same,
House number 4.
address is same.
In my lord, 1966 and 71, my lord.
Page number, can you help me with the page number again?
Page number 16 and 18.
Okay. Village Khanamuk, this one, right?
Yes, ma'am.
Moza Balipara, village Khanamuk, part 49. Nice.
But today I am only placing the IA for bail, my lord.
The records are here.
My lord.
We are deciding the entire matter. You are asking for bail. You are not being able to convince us.
Well, then matter may be kindly taken up tomorrow, my lord.
We have already taken up the matter.
Lordship, in WS Lordship, there is a in para 7 specific statement that Lordship that my father died in the year of 2004. And Lordship, but after 1989 Lordship, there is not a single document Lordship where Protiri's names contained along with his father Lordship.
In the voters list.
Voters list or any document Lordship.
After?
After 1989 Lordship.
Yeah, 96 document was not exhibited.
No,
Not even
not
produced.
exhibited.
Father passed away in 2004.
4.
And from 89 to the last 15 years, not even a single document of the petitioner and the father together. Isn't it?
Yes, Lordship. And after 1971 also to 1989, Lordship. Suddenly, one voter list has been placed, Lordship.
And 89, the petitioner was himself 30 years old,
Yes, Lordship.
if you go by page 21.
Yes, Lordship.
Regarding this, my lord, I need to take instruction live.
Madam, can you improve a case which is not there in the records? Records are before us. We've examined all the documents of the records. Fifteen order to 2024 last order. Last order. And this query was specifically, it was raised by the court. You have not given any answer on a query made by this court to sustain the statement regarding bifurcation of the villages referred to in the written statement. Granted counsel for the petitioner sought time, matter is accordingly adjourned. What is your explanation? Till now you have not given a plausible, acceptable explanation.
The client, but he said that Phonamuk and Miripatha, it's just adjacent to each other. And that's why, my lord, in 1989, it was Miripatha. In 1996, it was Miripatha along with Baligan and Bukagan, Baligaon and Bukagan.
What is your name, madam?
PM Ahmed.
PM Ahmed. Yes, Mr. Sharma, what do you say?
Okay. Only thing, this Lordship, Prosidi Abdul Rahman has to establish his link with his projected father whose name appeared in the voter list of 1966. That link is totally missing, Lordship. And voter list submitted by the Prosidi cannot be enough, Lordship, to establish one citizenship. And Lordship, I am again submitting Aziz Mia's case para 14, Lordship. Oh.
Aziz Mia have just been said that he has reported in the last decision he has said Aziz Mia has been reported.
Yes, Lordship, para 14.
Reported.
Yes, 2023 for GLT 246.
For GLT
246. Para 14. We are constrained to observe that a mayor claimed by a suspected person by referring to a voters list, claiming a person therein to be his father, is not a conclusive proof and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So Lordship, voter list is not enough, Lordship, to establish one citizenship, and we are in this. Even Lordship, there is no specific explanation regarding shifting and Lordship regarding name discrepancy. What happened to his fathers between 1971 to 1989? Again, after 1989 to 2004, what happened to his fathers? That things are not mentioned in the WS Lordship. Lordship, there is, I think, there is nothing to submit more, Lordship. So this totally failed to establish his link with his projected father, whose name reflected in the voters list of 1966, Lordship. That's all.
And as per verification officer's report, it was very much there that he is Indian citizen, my lord.
Whose report?
Verification officer's report.
And thereafter reference has been made. The references is all the subject matter of challenge. You have challenged the opinion. What have you challenged? Have you challenged the reference?
It does not look into the aspect that he was born in Panama.
You only challenge the opinion. There is no other challenge. The report of the Bureau has sent to the Superintendent of Police. From where are you making the submission, madam? From where are you making the submission that there was a report in your favor?
No, that Annexa 6, my lord, page number 26.
And what is it? Next or 6?
Page number 26.
26.
And here's report, Lordship.
I think, look into the LVS report.
My place of birth is Konamuk at point number 5. And at page number 28, point number 15, whether migrated to Assam, it is stated no.
So how will it make a difference to a case?
No, my place of birth is Konamuk then,
As per this report.
as per my report.
Of parents of what?
That is also mentioned, madam, my father's name is Muhammad Abdul Hamid.
What is your date of birth?
1/1/1966.
ERO has to be satisfied with this report, Dr. Satisfaction of ERO is required in this. ERO has to be satisfied with this report.
These entries were made by whom? Is it by the ERO?
No.
Is it by verification officers?
The verification of it.
I was just, This is what I was referring to, that this has been discussed by the learned tribunal member in para 6. Oh no, this is the police verification report is mentioned. Village Khana, same. And then there is a reference to birth certificate, absence of a birth certificate.
No, Mr. Sharma, we are just getting this clarification from you. See the records.
Yes.
There is one format which is called Format for Verification Officers Report.
Yes, Lord.
Now that is made thereafter. There is another format for making a reference. And that is first referred to the, because this, it was done by the ERO to the Superintendent of Police.
Yes, Lord.
Thereafter,
Yes.
Superintendent, we find a notice issued by the concerned foreigners tribunal.
Yes, Lordship. That,
Yes.
that was the law, Lordship, at that time, Lordship.
Yes, that time. Now, Madam is insisting that the first report, that is format for verification officer's report, the date of place has been, place of birth has been, place of birth has been written as Khanamuk.
Mm.
And there, she is also referring to clause 15, whether migrated into Assam, the ES has been struck off. So,
No. No. Whether,
please have the records, paragraph 7 onward, page 7 onwards. Please explain it to us.
Discuss. Maybe the birth certificate.
Lordship, in this report, if ERO is satisfied with this report, then his name was continued in the electoral roll, Lordship. If he is not satisfied, Lordship, with this report, then he send this report to the concerned SP to make a reference to concerned foreigners tribunal for opinion, Lordship. That is the law, Lordship. And Lordship, in the
ERO
next
sent
page-
to the SP, learned SP.
Yes, Lordship.
Okay,
And
it is not
in this,
satisfied.
respect, Lordship, if there is a ERO's inquiry, then question of SP's inquiry does not arise, Lordship. And Lordship, here in this case, in next page 11, Lordship, it was written as, Lordship. Whereas the Election Commission of India has ordered intensive revision of electoral rolls for 74 Rangapara Assembly constituency in Assam with reference to 1/1/1997 as the qualifying date, and whereas house to house enumeration was done during the period from 16 January 1997 to 15 April 1997, whereas the name of so and so, son of so and so, who has declared to be Indian citizen and also an ordinarily resident of so and so, has been enumerated for inclusion in draft Khanamukh electoral roll, and whereas the electoral roll of the said constituency was published in draft on 1997, including therein the name of the said Sri so and so. Whereas I, electoral registration officer, this part is important, Lordship. Whereas I, the electoral registration officer for said assembly constituency, having doubt about the citizenship of the said person, got the matter verified by an on the spot local verification, and whereas on consideration the report of such verification, I have reasonable doubt that he is not a citizen of India. Now, therefore, the matter is forwarded to Superintendent of Police, competent authority, and under the IMDT 1983 for foreign so and for deciding the question whether the said Abdul Rahman is a citizen of India or not. That much only, Lordship.
Which page of the record?
Page 11, Lordship.
But the enumeration in the report, where it has been stated that the place of birth is Khanamukh.
What they have stated, Lordship, that was written, but they have to place sufficient document regarding that to, then he is actually residing in Khanamukh, Lordship. There is no such document that what they have stated that are quoted in the verification report, Lordship.
Their statements.
Yes,
Their information
And-
provided by them.
yes, Lordship.
That means as per the response given by the proceedee
Yes,
while making the first inquiry,
yes, Lordship.
the formats, the forms are filled up. Thereafter, he comes and he gives an opinion,
Yes,
whether
Lordship.
it's a case of referring to for determination.
Yes, Lordship.
If not, he can drop the proceedings.
Yes, yes. Lordship.
And as you have submitted, that once the ERO gives a report for referring, then the SP cannot sit over it also.
No.
Further inquiry করবো না যদি করিব পরে যদি নাই বুলি কইতে হয় বুলি কইব পারে হয় বুলি কইলে নাই বুলি
In this case, you already read out, I mean, trying to understand on what basis the ERO, despite the information, okay, it is on the basis of what he stated. The proceedee stated that born in Khanamukh, which is in Assam, India, and then he was, what was the other information? Anyway, so on what basis he came to this opinion that this is a doubtful case which needs a reference? You were,
Just you-
you had read out, but what are the main? proceedings information was that he did not migrate to Assam and he was born at Khanamok. Proceed again.
Well, when the year is given a conclusion. Conclusion is not the subject of the. No, that's not. That's no problem to goes on to response. That will not make.
No.
It is at page 11, right?
Yes, Doctor. Page 11. Lordship, during inquiry, Lordship, LPO's report, whether registered as an elector of any constituency in India, yes, no was cut down. If so, serial number and part number of the concerned electoral roll together with the constituency number, name and state. Assam is so 1989 electoral roll. Whether a father is registered as an elector, same since only 1989 electoral roll and 2011, I think. On the basis of these documents, Lordship, ERO cannot satisfy Lordship that person concerned is a citizen of India. And Lordship.
Anything else? Sharma?
If required, Lordship, regarding this ERO's case, Lordship, I have already submitted one case and Siamuddin's case was, if required, Lordship, yes, Lordship. Yes,
Give the citation.
Yes, Lordship, I will provide. Read petition number 91 of 2019, Lordship reported case, and it was again
91 of
2019.
Okay.
Siamuddin.
spelling
SAYAM.
SAYAN.
UDDIN.
Citation is.
Date
It
of
is
the
reported
judgment.
case, Lordship.
Date of the-
I can provide the
I find.
yes, Lordship. 19 to 2019. And one appeal number 2. And again, Lordship, this position was reaffirmed by this honorable court again in read appeal number, Lordship.
Writ appeal means how writ appeal? That time
It
it was
is
the
single bench judgment, Lordship.
that was a single bench.
Yes, Lordship. I shall provide, Lordship, read appeal number. And recently, Lordship, I have on earlier occasion I have submitted, Lordship. Again, thorough discussion has been made in this regard, Lordship, in the case of Lordship Tukurjan Nessa. WPC 245 of 2019. SHU KURJAN.
WPC number.
245 of 2019. Tukurjan, SHUKURJAN. Tukurjan Nessa, NESSA. Date of judgment 28/2/2025.
Ten.
28/2.
28/2/2025.
25. This is on which point?
regarding ERO and LVO's report, Lordship.
For the building trust. Yes, sir.
My lord, read appeal number 170 of 2019 in Sayamuddin's case, Lordship.
Table number.
170 of 2019, decided on 29/7/2019. And 2019 4 GLT 456, Lordship, Sayamuddin's single bench reported case, and it was affirmed by the division bench in read appeal number 170 of 2019.
The single bench, the citation.
What I have cited, Lordship, 91 of 2019, it was reported in 2019 4 GLT 456.
4
Yes, Lordship, and it was reaffirmed.
Yes.
It was affirmed by the division bench of this honorable court.
It was a single judge.
Yes, Lordship. Yes, Lordship. And again, in recently in Chukurjan National, Lordship, all these
Have been read.
things. Yes, yes, Lordship.
Okay, we'll conclude this. Ekatranama, so is Miss P. M. Ahmed. Okay. Petitioner G. Sharma, Miss S. Kotoki, the Election Commission of India, Hazarika of State Council, and who's was the central government? CGC. Adhikari was there. Where is Adhikari?
MR.
MR Adhikari. Hearing is concluded. Judgment is reserved. My brother has got single bench. You have to rise, I think. Rest will have to give some bits. Total to Kinato. No, to the
My lord, item 22, my lord. Last occasion, my lord, the LCR, TCR was called for, but TCR not received.
TCR.
Yes.
Okay. 22?
22.
Item 33 is a mallet habeas corpus matter, my lord.
And my lord. Lord, order dated 1710,
I said to TCR. TCR is there, Mr. Why are you saying like this?
but in the cause list, my lord, is not.
What was this? You have to see the records.
My lord, item
Lord, fix a date, man.
We give a date, date, huh? TCR, 7 Yes.
Yes, Millard, item type 33, Millard, is a habeas corpus matter, Millard.
33 to early did.
Day after tomorrow, Millard, if possible, Millard.
Malaysia, item 28, 29, one is habeas corpus matter. Can it be fixed on 21st of this month?
I am praying for Millard 19, Millard, 33, Millard.
21st.
Or 19?
19, Millard.
Okay, 21st. Both the matters, 21st.
Millard,
21st.
21st.
Deeply obliged.
Read the 21st. Item numbers?
28, 29, my lordship, and my matter is.
What is your case?
One is habeas corpus case that he was being illegally detained, my lordship. And another one is that.
Now, where is he?
Now he is in Pokrajhar, my lordship.
So what is the relief you are seeking?
Relief I is thinking, my lordship, that I have also filed one IA, my lordship, for bail, my lordship.
That is not a habeas. How is it a habeas?
The habeas corpus is also there. WBC criminal is there. 34/2000.
What is it about?
It is about, my lordship, that at that time I don't know whereabout of the petitioner, my lordship.
Now you know.
Now I know.
So what is the urgency? What is the habeas corpus?
Now he's been illegally, my lordship. They have
That's a different matter.
Okay, my lordship.
That's not habeas corpus. Don't term everything as a habeas corpus.
Even item 33 is also same. Millard, there's a difference, Millard.
What is 33?
33 is, Millard, before, Millard, filing of this writ petition, Millard. By virtue of an ex parte order, Millard, the petitioner's mother was declared to be an foreigner, Millard.
Okay.
And that was put to challenge, Millard. And however, Millard, during the pendency, and this is still pending, Millard. During the pendency of the petition, Millard, it was specifically directed that she should not be deported out of this country, Millard. And she was continuously under, Millard, detention for 2 years, Millard.
That is not habeas corpus. We will take up your matter. We have understood. Mr.
Yes.
Adhikari has filed the affidavit,
Yes,
explained the
yes,
position.
yes.
That you have been pushed back. Then again you are being.
Yes, Millard.
Now, okay,
Again, she has
your
been
matter is, that's not habeas corpus, but we'll see. There's a legal issue.
My lord.
You are for whom?
I'm from the petitioner, Your Honor.
Hmm?
My senior is not here. Actually, I have talked to the NI authorities. They have told that they will file a reply. The previous reply they have filed, that should be converted.
Yes, Mr. Bharat. Mr. Prithvi?
Earlier, these revisions were filed as a criminal appeal.
Yes.
And in this regard, we have filed our reply on Lordship 23/5/2025.
Yes.
So since these appeals were converted into revisions,
Yes.
kindly consider our earlier objections as
We'll treat this.
treated as the.
This has been converted into revision already.
Yes, Lordship.
What is your prayer now? The objection filed on appeal has to be considered now. We'll consider it.
Yes, Lordship. On
When do you want?
the matter fixed on January.
Yes, sir.
And in item number 3 also, the Advocate General is supposed to appear, but he is unavailable today. So if all the matters were listed on.
Are these connected? Okay.
Yes,
No.
sir.
Lordship, these two were first two items were regarding another PS case, and the third item number is regarding another PS.
Okay. Joint prayer has been made for adjournment of this case, with a request to list in the month of January 2025.
6, Lordship.
2026. Prayer. But item number 3 is of the year 2021. How do we adjourn like this? No? Accordingly, the matter stands adjourned to be listed whenever this bench will be available.
Lordship, regarding our objection, that
We're not said anything. We'll consider. This is the bench which has been assigned to this matter. Okay.
Your Honor, we would like to file a reply to that objection.
In the meantime, the petitioners may file their response to the objection filed by